A little bit later, at 12 or around 12, I have code item 1 in code number 1, my lord. It will take some time. Obviously.
This item was listed on Monday last, my lord. It did not reach.
It's okay. Please give it to the court master.
Monday.
Whatever prayer, please give it to the court master.
May I please, your lordship? Lordship, with the consent from the other side, I beg to mention item number 22 of daily list.
22.
22, lordship. In this matter, lordship, we could not file the affidavit in opposition, so sometime may be granted.
Okay. You have taken consent of the other side?
Yes.
Okay. Consent of the other side and counsel for the counsel appearing on behalf of the learned CEC prays for adjournment, so as to enable him to file affidavit in opposition in the matter. This after ensuing vacation.
Obliged, lordship. Lordship, with consent from the other side, item 2 may be taken up after vacation. Mr. D. Sir of the arguing counsel is out of station. Item 2, lordship.
Okay.
After vacation, lordship. Obliged.
Okay. List after vacation is paid for by the counsel for the petitioner. You may say Kakoti.
Take a copy, lordship.
Kakoti. Yes.
May I please, your lordship? Well, I beg to mention for tagging of an IA in election petition number 1 of 2020, which is list fixed for tomorrow and daily list number item number 57, my lord. That may be brought to the record of diplomas.
May I please, your lordship? My lord, I beg to mention for listing of a motion matter tomorrow, my lord.
Give it to the court
Yes,
master.
there is urgency.
Give it to the court master.
May I please, lordship? I beg to mention for listing, lordship.
Can't you hear a simple thing?
Lordship,
Since morning, I've been telling, please give it to the court master, and again you are addressing me.
Lordship, item number 3 come up after vacation.
Item 3.
We are also awaiting instruction, my lord, in this matter. Item 3.
Okay, I intend only to issue a notice. Let me issue a notice. You wait
My
for some
lord.
time.
Then,
My lord.
matter may be.
Unless you see it's coming in the motion line.
My-
we can follow. Yes.
Wait, please, your lordship. Your lordship, I beg to mention item 36 and 37 of this list. I have taken the counsel of the Standing Council of Agriculture Department as well as the private respondent hearing. I am appearing for response number 3. Your lordship, we fix the matter after vacation.
Okay, 36
Immediately
and
after the
7.
vacation.
All sides are duly represented on the prayer made by learned counsel for the petitioner. This after ensuing vacation.
Obliged, your lordship, any fixed date may be given.
I'm not giving a fixed date right now. It will
Obliged.
be unmanageable after immediately after opening.
Obliged.
Supplementary cause list item number 38 and 39 delivery of order.
Yes.
Lord, it's for delivery of order.
Oh, acha. Okay. Owing to alternative remedy available, the request is not entertained. However, the period spent before this court will be entitled to be excluded from computation of limitation in both the cases.
Keep your blood.
Release item number 1.
May I please, your lordship? We need some more time to take instruction, your lordship, on behalf of respondent.
My lordship, I appear for the petitioners. In this, my lordship may issue notice then in this case.
Has been listed on on 3 occasions previously, my lord, for motion.
Twice.
Thrice, yes.
Today is the third day.
4th day, my lord.
I don't know. There are two order sheets here.
My lord, it was first listed on 13th of March, then 20th April, and then 18th of May.
18th May
No,
orders.
there was no bench on 18th May. That's why my
No,
lordship.
whatever be, it's not there.
Yes.
For Mr. A. Jain, counsel for the petitioner. And you are appearing on behalf of,
On behalf of Mr. S.C. Kyal for respondent number 2, your lordship.
okay,
MS Ardeka.
Mrs. Ardekar, counsel appearing on behalf of Mr. S.C. Kyal, standing also for GST.
Yes.
You are there?
Yes, lordship. I am appearing on behalf of Ms. K, respondent number 1, Union of India.
Miss
K. Fukan.
K. Fukan on behalf of
I am Ms. P. Tamuli on behalf of
P.
K.
Tamodi on behalf of K. Fukan. CEC for respondent number 1. Next one. Keeping the preliminary objection of maintainability open, issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition we served of the learned CEC and the standing counsel for GST in course of the day. Next one, the learned counsel for the GST prays for and is granted time till the next return date to file their affidavit if so required. The list after 4 weeks. Just a moment.
Yes.
Notice including notice on the prayer for interim relief.
Oh.
I may be allowed to do this petition, my lord. Again,
Mr.
with liberty, my lord.
Okay.
Liberty, my lord.
Upon instructions, the RS Michelle and counsel for the, sorry, RS Chauhan, counsel for the petitioner, seeks to withdraw this petition with liberty to approach again. Here is allowed. Matter stands dismissed from withdrawal with liberty as platform. Mr.
As Dr.
S. Datta, standing counsel for
Revenue Department.
Revenue Department, and Ms. M. Burman, the government advocate, are present.
Obliged.
T for motion.
Yeah, there.
Notice may be.
Mr. Zaid Hussain, counsel for the petitioner. And Ms. M. Burman, the government advocate, appearing for the respondents.
All the
Yes,
respondents.
Claiming that the police authorities had taken land on the petitioner or rent, which remains unpaid. The present petition has been filed under Article 226 of the Constitution of India. Notice extra copies. Pendency shall not be allowed to examine the claim of the petitioner and to release payment. Certified copy of the order we produced before whom?
My lord. Respondent number, my lord. 2 and 4, my lord.
2 and 4.
Item number 4.
Obliged. My lord.
It's okay. I'm issuing a notice. Mr. B. Sharma and counsel for the petitioner. Ms. M. Burman and the government advocate appearing for the
1 and
respondent numbers
1 and
1 and 2. The petitioner is a asset reconstruction company under the Sufficy Act. And they had moved the deputy commissioner for issuance of process for taking over physical possession of the stressed asset. Full stop. Although the application was filed on 6/2/2021, right?
Yes, madam.
Comma, the Deputy Commissioner Nalbari has not disposed of the said petition or passed any order thereon. Full stop. Accordingly, it manifestly appears that the Deputy Commissioner Nalbari within the respond number 2 is not following the mandate of section 14 of the Surface Act. Next paragraph. Accordingly, the present petition has been filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the learned government advocate for respondent numbers 1 and 2. Next, the petitioner shall take steps for service of notice on the respondent numbers 4 to 8 by registered post with AD. Liberty is granted to the counsel for the petitioner to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next paragraph. Having regard to the fact that petition before the Deputy Commissioner Nalbari was within bracket respond number 2 was filed on 6/2/2021. The court expects the Deputy Commissioner Nalbari to positively file an affidavit as to what was the cause which prevented him from passing orders on the said petition for more than 2 years. Next, the learned government advocate shall transmit a copy of this order to the respond number 2. In the meanwhile, the petitioner shall also produce a certified copy of this order before the Deputy Commissioner Nalbari and submit a proof thereof on the next date of listing. Next para. The pendency of this petition shall not be a bar for the respondent number 2 to take up and to pass appropriate orders on the said petition. Referred above.
I
Yeah, please, Your Lordship. Your Lordship, the writ petition order prayer has been duly followed and it has been communicated to us.
Okay. Miss Arjha,
Ajahn.
learned counsel for the petitioners, has submitted that during the pendency of this petition, the arbitrator, the appointed arbitrator, has taken up the application under section 3 within bracket capital G within bracket 5 of the National Highways Act 1956, which was communicated to the petitioner. Accordingly, she has instructions not to press this petition.
Copy has also been sent to us.
Yes, okay. Ms. M. Burman, and the government advocate is present. Matter stand dismissed. At now, please.
Obliged.
six.
There is no representation from the petitioner. However, Mr. H. Chandran, additional senior government advocate for the state of Arunachal Pradesh is present. Issued notice returnable in 4 weeks. Who's appearing as CGC? CGC is not there. Mr. Chandran,
No, Lordship.
CGC is not there.
It's part, but this is a party here, Lordship. But the council.
Union of India is a party.
Lordship.
Okay. As the petitioner is unrepresented, 1 week's time is granted to the petitioner to serve extra copies of the writ petition to the learned CGC for respondent number 1, to the learned additional senior government advocate for respondent number 2,
2 and 5.
and to 2 and 5, and to the standing counsel for NHPC. To stop. In the event standing counsel for NHPC representing respondent number 3 and 4 is not available, the petitioner shall take steps within a week for service of notice on the respondent numbers 3 and 4 by registered post with AD. List after, make it 5 weeks, list after 5 weeks.
So where,
Next also same,
Same lordship,
parties are same,
same lordship.
okay.
And
Same.
lordship, in item number 31, the same matter lordship. There, this matter has been transferred from Jamnagar Bench lordship. Their notice has been issued. But after transferring of this matter, it's listed here lordship. We have a
First time,
first time lordship. We have
notice is served.
notice served in that case lordship.
No,
In
no,
that-
no. After transfer, notice has been served.
No.
Okay.
31,
issue-
32, 33, 34 and 35 lordship.
Okay. No decision from the petitioner. Mr. H. Chandan, additional senior government advocate for state of Arunachal is present. Next, as the matter is received upon transfer, let a court notice be issued on the, you are appearing?
Yes, sir.
On respondent numbers,
Lordship,
court notice on whom? Respondent numbers,
lordship in item 31 to 34, I am the respondent number 2 and 5 lordship.
except 2 and 5. Except respondent numbers 2 and 5. Notice to all, huh? Court
And
notice to all.
lordship in item number 35, there I am for respondent number 3 and 4 lordship.
35, 3 and 4.
Item 35, I'm not in that case. Okay, and item 31 to 34 and there.
31 to 34, Mr. H. That's it. Counsel for the petitioner. You're there in item 1 and 2 also? No.
6 and 7.
6 and
In
7.
6 and
6 and 7,
7,
you are there?
Yes.
6 and 7, okay. You take steps within a week. Extra copies and steps
Problems.
much obliged.
Item number
after
8.
4 weeks, after 5 weeks. All this matters, 5 weeks.
Problems.
My please, your lordship, lordship, yes, I see counsel, MS lordship out of station lordship. Lordship, kindly list the matter on Monday lordship.
I have to issue a notice. Even if the counsel is not there, I have to issue a notice unnecessary. This matter is prolonging. Mr. D.P. Varam, counsel for the petitioner, and Mr.
N. Barbato Ghai.
and Dr. Ghai, on behalf of Mr.
M. Smith.
M. A. Sheikh.
M. Smith.
M. Smith, okay, M. Smith, counsel for ESIC. And appearing for all the respondents. Next one. Where is the proof of your winding up petition?
Lordship,
Company winding up, where is that? Except for your letter, what is the proof of the company is wound up?
Lordship, actually, my company did not start operations.
It's not dependent on that. Once you have registered your company, it is your case that you are winding up the company.
Yes.
So where is the order of winding up?
Lordship, I'll just, in an additional affidavit, I'll bring it on record.
Because without that, your company exists and EIC liability will remain.
Yes, yes. Therefore, Lordship, I will bring all the documents of winding up
Okay.
by an additional affidavit.
Okay, then say that. Both sides are represented. Mr. D.P. Varan and counsel for the petitioner. Place for plan to file additional affidavit to bring on record additional documents on which he intends to rely on. Okay. It is after
Additional
vacation.
documents of winding up.
Whatever you want. I'm not saying, I'm not limiting you. After vacation,
Yes.
9,
Well, if the metro parties to my lord.
That's fine. you're there for APDCL.
Yes.
You'll have to give them a connection.
Yes, Lordship. Lordship, even they annex a judgment, Lordship, where it said electricity basic amenity. So according to that judgment, can dispose of Lordship. We'll give them a connection within a week.
Okay. For the Science Sarkar and Council for the petitioner. And Mr. R. Goel and expanding counsel for the APDCL.
Right, was 101,
Appearing for respondent number
123, Lordship.
1, 2, and 3. By filing this petition under Article 226 of the Constitution of India, the petition is seeking a direction from the APDCL authorities for providing new electricity connection in the residential premises of the petitioner. First of all, it is submitted that due to family dispute from the other family members of the petitioner has disconnected the electricity and energy supply to the residential house of the petitioner. Next, you should notice a motion returnable in 4 weeks. Requisite extra copies of the petition we served on the standing counsel for APDCL. Appearing for respondent numbers 1, 2, and 3. So the petitioner shall take steps for service of notice on respondent numbers 4 and 5 by registered court with AD. Next paragraph. Having regard to the fact that electricity energy supply is an essential service, and that the what is it called? That regulation, what is the name?
ARC.
ARC regulation
Yes, Lord.
provides for supplying electricity energy on realizing appropriate security. Even from persons who are not the owners of the land. As an interim measure, the court is intended to provide that the pendency of this petition shall not be a bar for the petitioner to for the judicial authorities to examine the application of the petitioner for electricity connection and provide the same and provide such connection, which will be subject to further orders that may be passed by this court. This after 4 weeks.
without NOC from the co-partaban. They are not
So
giving.
they will understand what my order is.
Obliged, Lord.
What like- And
Mr. Lordship,
Okay.
my lord, better list to my lord. Then for the basis of porter license, my brother,
Yes,
my lord.
Heard. Mr. M. Saranyal and counsel for the petitioner. And Mr.
D Deca on behalf of B Deca, CCC.
D. Deca on behalf of Mr. B. Deca, done the CVC. Appearing for the respondents. Next paragraph. This is a second round of writ petition, for which the petitioner is seeking transfer of his porter's license to his brother-in-law, which is permitted by the appropriate guidelines of the NF Railway.
That is 29/10.
It's okay, I'm not. having a difficult
my
one. You should notice you should notice a motion returnable in 4 weeks. Requisite extra copies of the writ petition we served on the runner CEC appearing for the respondents. Next paragraph. having taken note of the fact that in order to that despite an order dated 1/8/2018 passed by this court in WPC 4332 of 2018, wherein the railway authorities, including the divisional commercial manager, Lumding, NF Railway, was directed to consider the claim of the petitioner for transfer of porter's license number 233 of of the petitioner from Sri Shiv Pujan Yadav, SHIV, next word PUJAM Yadav, to the petitioner named Amit Chauhan. The court expects the railway authorities to positively file their affidavit in opposition on the next date. Feeling which the court will presume that the respondents are not contesting the claim of the petitioner, and appropriate orders will be passed on the next date. As a question of livelihood of the petitioner is involved in this petition. As the petitioner shall, the petitioner shall produce a certified copy of this order before the divisional commercial manager, Lumding, NF Railway. In the meanwhile, the learned CEC shall also transmit a downloaded copy of this order to the railway authorities to bring the order to the notice of all the respondents. This after 4 weeks. You download and transmit the copies.
High level.
Download it from the website and transmit it to the authorities.
11.
The pendency of this writ petition shall not be a bar for the authorities in the NF Railway to examine the claim of the petitioner and to pass appropriate orders thereon. Yes, Mr. Sinha.
Yes, my lord. Demarcate the language. I am stopped by the person concerned who is on the. I could not manage the. Continue my construction.
You should have seen the online video of this court yesterday.
Yes, my lord.
Item number, it was. You see, now you tell me you have sufficient experience. I am repeating the same word which I used yesterday. You have sufficient experience in bar, correct? Under the Assam Land and Revenue Regulation, please show me any provision by which on representation the demarcation is done, or you are required to file an appropriate application for demarcation.
Yes, under 21 and 22.
No, is it done on representation? Is that you have found?
That is actually. Formally, it was applied, my lord, with the requisite form, my lord.
Show us.
Copies I don't have now, my lord.
Then you file it.
Fine.
Next week or next week after vacation it will come.
No, I'm dismissing it. Why should I keep it pending? You file your application for what? For that, I would not increase my pendency.
In fact, para 7, my lord, he is trying to institute some dispute with the neighbor, my lord. In that case also proper application has to
Yesterday, I showed you the law.
be.
What happens?
That is the case, my lord. Then provision of
Or I may be
services
allowed to,
also
my lord,
applied.
if possible, my lord, after vacation, my lord, or I may be allowed to.
No, but why do you need this pending?
Because that application, my lord, I have to call that one. Whether she has filed application or not, there.
There is no statement here. You can't include that like that.
Yes, my lord.
You said you have filed a representation.
Representation subsequently filed after that requisite form, my lord, under 22.
You see, once you file a petition, in the DC's office, a mutation case is registered.
Yes.
Yeah, I will mail up to them.
This Bata became famous because at that point of time I had to use many shoes running about here and there
Yes, madam.
to gather some experience.
These are up to me.
And my, what you call, one of the advisors is sitting behind, Mr. Mukhtar. Those were the days where you had to run to DC's office to do this small works.
I will up to them.
I'll give you liberty to move.
Yes, madam.
Mr. B. Sinha, and counsel for the petitioner, and Ms. M. Burman,
Two and three.
government advocate appearing for respondent numbers 2 and 3. And Ms. G. Hazarika, standing also for Revenue and Disaster Management Department, appearing for respondent number 1. Full stop. By this writ petition filed under Article 226 of the Constitution of India, the petitioner projects that although he has filed representation for demarcation of the of his plot of land, but the authorities have not taken any step. Next para. Having regard to the materials available in the writ petition, the court is of the considered opinion that under the Assam Land and Revenue Regulation, the authorities would not demarcate land on the basis of a representation, but that can only be done by an appropriate application which is registered as a demarcation case. So accordingly, the court is inclined to close this writ petition by granting liberty to the petitioner to file an appropriate application for demarcation as provided for under the Assam Land and Revenue Regulation of 1986 and to pursue the same. With the liberty as indicated above, this writ petition stands closed.
13,
Okay.
May I please?
Yes.
Also, in this matter, no confidence against the chairman of municipal board has been
Yes.
said.
You for the
With the
department.
permission of your honor, I want to inform that we have filed a caveat before filing this writ petition. Same, it is not shown in the cause list.
There must be some defect.
We inquired about that, informed that file was
I
not
may give a copy to
cancelled the
the-
caveat, sir.
You are appearing for whom?
Preparing for respondent number 428.
4 to 8.
Which is this one?
A copy may be served, it is not served.
I may give a copy to you.
Matter may be listed on the net page.
I'm issuing a notice at this
May
page.
come up from the net page, my lord.
I'm issuing a notice at this page.
There is an urgency lordship. Meeting has been called tomorrow again, lordship. By the deputy commissioner. He has no authority.
Then you give him a copy, we'll take it up at 2 o'clock.
Lordship,
Give him a copy.
lordship. Okay.
The matter reads non-payment of
I'm
motion to
saying
appeal.
this.
Notice may be issued at this stage, value.
Had Mr. Sheikh Mukhtar and the counsel for the petitioner and Mr. Anu Padiyal understanding also for the irrigation department, appearing for all the respondents. You're for all, Mr.
Lots,
There is
I
also
all,
for
1 to 5.
Claiming non-payment of contractual dues. The present writ petition has been filed in Article 326 of the Constitution of India. Notice extra copies. Pendency shall not be a bar.
Second is same.
Second also same.
15,
Okay.
sixteen,
It appears that the name of the learned counsel for the petitioner is not reflected in the cause list. First, hence, there is no representation of the petitioner. However, Mr. B. Dury, learned government advocate, appears for
It's for 3, 4, and 5.
respondent numbers 3, 4, and 5. And Ms. G. Hazarika, learned government, Standing Counsel for Revenue Department, appears for respondent numbers 1 and 2. Next paragraph. The petitioners claim that they are entitled to 2 plots of land by way of inheritance from their grandfather, namely Jagan JGM, next word Nath Agarwal, Houston. On 24/3/2023, the petitioner number 1 had filed an application before the Additional Deputy Commissioner, Kamru Metro, for correction of the land records by insertion of their names. Houston. Although the Additional Deputy Commissioner, Kamru Metro, is stated to have issued a letter to the Circle Officer, District Revenue Circle, while letter number KRC within bracket M 165/2020 part PT full stop /403 dated 3/4/2023 regarding correction of land records, but the petitioners have come to know that the Circle Officer, District Revenue Circle, has illegally converted the periodic patta land to government land without issuance of notice or information to the petitioners. And they came to know about it on 10/5/2023 when the petitioner number 1 visited the office of the Circle Officer, District Revenue Circle. Next panel. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition be served to the learned state and department counsel within a week. Next one. As an interim measure, the court is intended to provide that the order passed by the Circle Officer, District Revenue Circle, of converting the two plots of land VZ number 1 and 2. You get it from this fact. Shall remain still. The learned, as the counsel for the petitioner is absent, as his name is not reflected in the cause list, the learned government advocate and the learned standing also for the revenue department, they are both transferred the copy of this order to all the respondents to bring it to their notice. Next, the court master shall call the learned counsel of the petitioner in the phone number disclosed in this repetition, so as to enable him to take steps list after 4 weeks. Just stay so and so, and any other consequential orders, stay both number 1, order of the civil officer, and number 2, any consequential order that may have been passed by the authorities. You can call him and tell him how order passed.
17,
I'm issuing a notice. Reading your repetition, I had a thought coming in that perhaps time has come for the legislature to stop what you call unnecessary disclosure of information through RTI. Your petition shows that it is what you call this is a fishing expedition. You have your own intention and you are roving and fishing inquiry through RTI applications. It's a nuisance, but I can't help it. That is the law. First impression is that this petition is nothing but a nuisance, but I can't help it. That is the law. I can only feel bad, but can't do anything. Mr. Hussain, counsel for the petitioner, and Ms. N. Bora, Leonard, standing counsel for
PNRD for the
PNRD department, appearing for
1, 4, and 5.
respondent numbers 1, 4, and 5. And Mr. B. Deoril, the government advocate, appearing for respondent number 1 and 2. Information Commission also will appear.
Information
Commission.
registrar some information.
I don't think they have a.
Yes.
Appeal was filed and appeal was disposed of by the some information commission.
No, that is okay. Issue notice returnable in 4 weeks. Revisit extra copies of the repetition which are going to the state and department council in course of the bill. List after 4 weeks.
Pendency of the writ, my lord. Pendency of the writ shall not be allowed if they want to.
Pendency of the repetition shall not be a bar for the authorities to disclose the information as required by the petitioner.
May our name be reflected and a copy to us.
Oh, okay. Copies will give it. The registry shall reflect the name of
Yes.
G. Assam and the cost is by listing the matter next.
18,
May I please? Lord, at the very outset, Lord, I beg Lord unconditional apology. Lord,
Why?
for some Lord typing error
Okay.
in somewhere. Lord, where Lord it should be Lord Khutian number 82. Lord, somewhere it is written Lord 43.
Now, number 1, under which law
Malad.
these khatyans are issued? Can you tell me?
Lord, that is Lord under the Lord. It is reflected in the Lord. Golpura Tenancy Act, 1929.
Gwalpara Tenancy Act. So, assuming that you are right, did the government ever appoint you as a tenant? In a government land, you become a tenant. Very surprising.
That Lordship only CPS 15. The particular person.
That's what I'm asking you. Did the government give you tenancy and made you a tenant in their land? This is something I've never heard of.
Lord, that is reflected in the Lord Khutian.
No, but you'll have to show us legality of it. Mere entry in the record of rights doesn't create a title. You have to show us that you were lawfully inducted as a tenant by the government. It's not a patta land.
It's not a patta land.
And then
Now, Malad, subsequently, Malad, what happened, Malad, since we are in Malad possession,
second thing will come later.
Malad.
First thing first. You have to first demonstrate that you have a legal right to be there.
Now, one thing, Malad, they are in possession since Malad, the last 80 years.
And-
Now,
okay.
somebody's name who are not
So-
in possession,
So second thing, what is the procedure prescribed in law to have the land allotted in your name? What is the procedure?
now, that we Malad, new Malad scheme, 2019, there is a scheme, Malad.
How do you do it? You know the procedure.
Yes, certain criteria has been Malad prescribed. Certain criteria has been prescribed under the scheme.
So therefore, unless you file a kabula, you can't be given an allotment of land. Your petition itself is liable to be dismissed. Just because you file a representation, give me land, doesn't authorize the court to pass an order to dispose of your representation.
Malad, that is fine, Malad, but one thing, Malad, since we are in possession, since Malad, last 80 years, but somebody's name appeared in the Malad, Sita copy, Lordship kindly see the Malad. Those who are not possession,
Then third question, what is the procedure prescribed under the Assam Land and Revolution for removal of name in the from the chita, from entry in the revenue records? What is the provision?
yes, that is prescribed, Malad,
So
format is there.
all three grounds your petition is liable to be dismissed. High Court can't take over land acquisition cases.
Malad, in that case, Malad, we may be Malad given liberty to approach the Malad appropriate authority
Okay,
for Malad.
but you'll have to report this, Ms. Hazarika. Government land, a tenancy is created by issuance of khatiyan. And the government is so silent about it. And others who have pata, we issued in their names, allotment letters in their names, from to them you are evicting.
But they have not annexed any supporting documents regarding this.
That document itself is sufficient. You see, what documents you will have for government land, except for a chita and a khatiyan. They should bring you a khatiyan. If that is correct, it is good enough. There can't be any document for government land.
Like
Will
you
you-
stated
will-
that, in Jamabandi, some
No,
other
you
thing
see,
has
here,
been appeared.
here we have about 25-30 learned lawyers sitting. Can you give each of them land document for a government land? Then everybody will be so happy. Except Mr. Tiwari, who is very deep thought. He may not like it. He would like to earn it. Right, Mr. Tiwari? No, don't stand up. Don't stand up.
Depends upon places. In Andhra Pradesh, God knows what happens with the government land. Over here, one doesn't have a choice.
Okay, had Mr. M. Mandal and counsel for the petitioner.
One briefing submission, Malad, respondent number 8 to Malad 11, they are not having Malad possession, but their name included in the Malad Sita copy. Recently.
So that you will have to just take a trouble of
Yes.
reading 163 capital D
Malad.
of the what you call rules under the Assam Land and Revenue Regulation.
Malad, we may be given liberty to.
Huh?
the approval of-
M. Mandal and counsel for the petitioner, Mr. G. Deori, and the government advocate appearing for respondent numbers 4, 5, 6, 7. And Ms. G. Hazarika, standing also for revenue department, appearing for respondent number 1, 2,
2 and 3, Lordship.
1 also.
One
Acha,
and
one
is
Mr. Deori will be there. Okay, 2 and 3 by next para. The present writ petition has been filed under Article 226 of the Constitution of India for by which the petitioner is seeking direction upon the respondent authorities to give settlement of the allotment of the land to the petitioner or for restoration of the old Khatian number 82 dated 2/1961 in respect of the land more fully described in the writ petition. First off, it is projected that although the private respondents are not in possession of any part of the said land, but their names have been entered in the revenue records. Next paragraph. In this connection, the court is of the considered opinion that for alleged entries projected to be illegally entered in the land records, creating third-party rights, there are provisions in the Assam Land and Revenue Regulation to challenge such entries. Moreover, the petitioner has prayed for directing the respondents to give allotment of land to the petitioner. But that is not a matter which can be judicially decided. And therefore, under the Assam and some land and revenue regulation and rules framed thereunder, there is a specific provision for prescribing the manner in which land would be allotted. What is the scheme which has come now? That land allotment is, what is the name of the scheme?
Some land.
So the learned standing counsel for the Revenue Department has submitted that recently the government of Assam has launched Vasundhara scheme to deal with the applications for allotment of land or settlement of land.
But Lordship, that portal has been closed. That portal has been closed on March, Lordship.
It is closed.
Yes, Lord.
Then
As per my knowledge, portal has been
okay,
closed.
then so therefore the petitioner would have to comply with the procedure prescribed for seeking allotment of land. To stop. Accordingly, the court is inclined to close this writ petition with liberty to the petitioner to move the appropriate authorities. If they are aggrieved by entry of names of the private respondents in the chitta, which may prejudicially affect their right in respect of the Khatian entered in his name, and to make an appropriate application before the responding authorities for settlement of the allotment of land. First of all, with liberty as indicated above, this writ petition stands closed.
Present policy, Assam land policy, 2019 is
Okay, Assam Land Policy 2019.
19.
It's this land revenue regulation, you say that a procedure for allotment of land is also covered by Assam Land Policy 2019. Okay.
Not regular, I'm sorry. I did not 16. My name has been.
Your name is not from. You take steps. I've given you 1 week's time. I wish you notice.
My present will be.
I recorded. Mr.
LK board.
LK Bara. Item number
16.
16. But you take steps.
Right.
Correct. I passed some interim order also. I passed some interim orders. You provide certificate copies to the authorities. Check it up in the.
19.
I'll issue notice.
My lord.
Uh, Mr. R. Sharma, and counsel for the petitioner, and Ms. M.D. Bora, and standing counsel for
Transport Department.
Transport Department.
For 1 and 2,
respondent
my lord.
numbers 1 and 2. And Mr. D. Deori, and Committee Advocate, appealing for respondent numbers
4, 5, 6, 7.
4, 5,
6, 7. Yes.
6, and 7. Next paragraph. The petitioners are agitating because of having appropriate stoppage for the Tata Magic service, taxi service under the Mangalde town. In the Mangalde town. Next, I issue notice of motion written over in 4 weeks. Requisite extra copies of the petition be served on the State and Departmental Council in course of the day. Next, the petition shall take steps within 2 days for service of notice on respondent number 3 by registered post with AD. Next, pendency of the petition shall not be a bar for the respondent authorities to examine the claim of the petitioner and pass appropriate orders thereon.
Thank you.
I'm deeply obliged, my lord.
Lordship, no coercive action may.
No, lordship,
That I
will
can't-
enforce this order.
that I
I
can't
have
do.
received instruction from
That I can't
lordship.
do.
In fact, my lord, I have received instruction also from DPO.
That
Deeply
I can't
obliged.
do,
I
because
will
then what would happen, there will be chaos in the road.
My lord.
Mangalde, we all know the Mangalde road.
Lordship,
I have
this,
to,
when fine is imposed up to the rupees 10,000 rupees.
Yes,
no,
as per
I know
the-
that, but you see, for each and every case, you'll have to challenge it. In a criminal, this traffic challan is a sort of, a penalty which has criminal consequences. Correct? So you have to challenge it. If you dispute that the challan was incorrectly imposed, then you have to challenge it. So therefore, I can't do it. And number 2, you all know this Mangalai town road. Because every time we have to travel that way, we have to cross that. So this, if I give a judicial order and this, you see, Mr. Sharma, if they park it properly, there's no issue. But they're not parking it appropriately. You see in Jalukbari what is happening. So there is some practical difficulties. I won't give a judicial order right now.
I'm deeply obliged, my lord.
20.
Yes,
Your Lordship, the petitioner approached,
I can only issue a notice. I won't give an interim order.
Your Lordship, the petitioner has been approaching the respondent since the time when he obtained the.
No, you see,
settlement, Your Lordship.
you are so polite. You means your petitioner.
Yes,
He is so polite that when somebody is enforcing his rights, he doesn't go to the police station.
no, Your Lordship.
He writes to the authorities for what you call for taking steps. How the fishery department
No,
will
Your
take
Lordship, the
steps?
petitioner had approached police station also,
Where is
but
that?
they said that you approached
Where
because
is
it has
that?
not been received by the police station, so it cannot be made as an annexure in this case, Your Lordship. OC has told the petitioner to approach the circle officer. So he approached it,
But
even he approached
I
the.
understand, but you
Yes,
see,
Lordship.
can a circle officer evict someone?
No, Your Lordship, the petitioner, he want that the wheel should be demarcated so that there should not be any dispute. But that has not been done.
Where is your petition? I was reading page 22. You don't say that. You're saying that you evict to the circle officer. you're also claiming what you call remission of
Yes.
your what you call this fishery case money, right?
Yes.
So you have a remedy available. Why you want to stay the tender process?
Your Lordship, because if tender continues, then it is something affected, Your Lordship, because his.
You can seek remission. You have an alternative remedy. You see, I'm just asking you
Yes.
because I did not understand. You can't fish. Your tenure was how many years?
For 1 year.
For 1 year.
Yes.
In 1 year, you can't fish. And you want a stay order for the other tender, and you think that
No, Your
you'll
Lordship,
be able to
if-
fish.
If that particular bill is state, I have no objection for others. Only these three
No, I
bills, Your Lordship,
understand. I'm just asking you only that.
because
For
my
your
issue
bill.
has not been decided yet.
No, no, for your bill, I'm asking you.
Yes, Lord.
If you can't fish now, can you fish tomorrow? You can't do it. So why stay the tender? Let some good musclemen come and take over the fishery.
That is my grievance, Your Lordship. That has not been redressed, Your Lordship.
You ask for remission, you move the government for remission, but I'm not staying it. Heard Mr.
That's that.
S. Deka, then counsel for the petitioner. And Mr. G. Deori, the government advocate appearing for respondent numbers
3, 4, 5.
3, 4, and 5. PNRD, who is there? You are there. Ms. Andora, and the standing counsel for PNRD appearing for respondent numbers. Please come here, I can't listen.
One, two, 7, 8, 9, and 11.
Okay. Next one. But filing this repetition under Article 226 of the Constitution of India, the petitioner who is this is yours is a society or an individual,
Individual, Your Lordship.
the petitioner who is settled with 3 numbers of fishery bills, namely Hakali, PHAKALI bill, Huru Hakali bill, SARU, PHAKALI bill, and Dhananjay bill, by settlement order dated 10/8/2022. Is seeking a direction for staying the tender process initiated on 9/5/2023 by claiming that some people had illegally occupied the bills allotted to the petitioner and were catching fish illegally, but despite representation, no action was taken. Hence, once the petitioner raises a grievance that if the bills are settled again, they would suffer irreparable loss. And in the representation dated 19/5/2023, the petitioner has also paid for adequate compensation, along with prayer for eviction of the illegal encroachers, which was made to the Additional Deputy Commissioner, Revenue Department, Nagaon. Next, I issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition be served on the United State and Department Council in course of the day. Next, the petition shall take steps for service of notice on respondent numbers 6, 10. 11 you are appearing,
Yes, let's.
6 and 10. By registered post with AD. Next para. Heard both sides on the prayer for interim relief. First of all, as the court finds that the settlement of fishery is for a period of 1 year. And the grievance of the petitioner is that he has not been able to properly fish in the last during the current settlement period. The court is of the considered opinion that as petitioner has a remedy of applying for remission of the case money, the petitioner is not entitled to stay of the tender process for the coming season. Just accordingly, prayer for interim relief is refused. List after 4 weeks. Next, the pendency of the recreation shall not be a bar for the petitioner to move the competent authorities for seeking remission of the what is it called? Case money that will be considered in accordance with law.
21.
21.
Made use of also.
Bar. DK Das, counsel for the petitioner. Yes,
I shall get the instructions.
your name?
I'm Kalika, Your Lordship.
I am Karita, I'm standing counsel for
Excise Department.
Excise Department, appearing for respondent numbers.
1, 2, 3, 4, 5, and 6, Your Lordship.
1, 2, 3, 4, 5, 6.
I'm for 7 years.
Mr. B. Devi, government advocate, appearing for 7. Next para. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the requisition with Southern State and Department counsel in the course of the day. Next, the pendency of the reputation shall not be a bar for the competent respondent authorities to examine the claim of the petitioner for issuance of IMFL on license
On license.
in accordance with law.
Obliged to.
41.
My learned friend was to produce the
Yes,
instructions.
yes, yes.
Lordship, I also verified the portal, Lordship, whether my signature is not uploaded or not. Although, Lordship, it is the scan copy, Lordship. And hence in the scan copy, Lordship, sometime what happened, the appropriate, all the portions are not entrust, Lordship, not come in, Lordship.
Okay.
And I downloaded and I also printed the papers, and also from the petitioner's documents, it appears that the signature of the respondent 7 is there, Lordship. How it is, Lordship? Kindly see page number 149, Lordship. 135A, Lordship. One 135A, Lordship. In the last portion, Lordship, after 24, Lordship. Page number 24, Lordship.
Yes.
35A, 24, DECA and Associates. The seal is there, Lordship.
Okay.
In the petition, read petition, Lordship.
Yes, I've seen that.
Yes, this is the signature, Lordship. That was not come in the portal, Lordship. It is scan values, or in the original, Lordship, it is available. Original petition. Yes.
It will be a dangerous thing, my lord.
No, 140A is also there.
My lord.
Yes.
140 capital A. Signature is there. Maybe during scanning, first part is gone.
Yes.
Second part doesn't come.
These are the documents. In
No,
the
no.
tender, he has no more given. These are documents.
No, but whatever is showing
My
from
lord, it will
135.
be- my lord, the sanctity of the whole process will go, my lord, if my learned friend's argument is to be accepted.
No,
Kindly appreciate.
135A, his signature is
Yeah,
there. Seal
No,
and
This is
signature.
the document.
No, no, this
This is the document which are part of the tender. Where is the signature in the tender? That's why I posed the question yesterday, my lord. Supposing my tender is rejected on the ground that in the tender each and every page I have not signed, would your lordship entertain that writ petition? Same test has to be applied here. It is a dangerous thing, my lord. Now they're putting, having the signatures in the downloaded thing. It is not there. My lord, we also know why this contract has been awarded to that respondent. We know everything, but we cannot say, my lord.
These are not.
At whose telephonic call, my lord, this has been done, we know. I can say this much on the telephonic call of a lady minister, my lord, this work was awarded.
Let me examine it.
No, my lord, things are going out of control, my lord.
Please let me examine it. Mr. Chaudhary,
Yes, yes, my lord.
no, we'll have to reject your argument. We'll have to reject your argument. See this. You see this, is page 1, that is the NIT, page 107.
107.
Yes. Is a part of tender.
Yes, Lord, sir. 107
Yes, it's a part of tender.
in MIT.
No, I don't know. I'm just asking you. Is this a part of tender? Page 107.
107 in the writ petition. Lord.
Yes, yes.
Yes, it's a part of tender.
It's a part of tender.
It's the first portion of the tender.
No, no, it's okay. I'm just coming one by
Yes.
one. Now you see, just see this page.
Yes, yes.
Page number 1 is here,
Yes, Lord, sir.
correct? And the seal and signature is here, parallel. In this 107, this parallel signature is not there.
107, Lordship.
Yes,
It is
107.
for Rupam's property, it's the petitioner's, Lordship. It's the document of the petitioner. Lordship.
Okay. So where is this document?
No, that was not annexed by in the petition, Lordship. It is annexed from 135A, Lordship.
135A.
Yes. Although in the Lordship, in the list of the documents also, they stated that the annex that the copy of the copies of the complete set of the tender documents submitted by the respondent is 134, Lordship. But Lordship, it is appeared that 134 and 135 is not related with the. Yes, it is the type copy, Lordship. 134 is there, Lordship.
No, it's type of 135A.
Yes, 135A, Lordship, it is a part of the respondent, and 107 is the part of the petitioner, Lordship.
Oh, acha.
Yes, these are the scanners, Lordship. It is a portal, Lordship. We have nothing to do here, Lordship. It is
No,
the
no,
government
but
portal.
No, no, no.
Yes,
But it
Lordship.
must match.
Yes.
Is it not?
Yes, Lordship.
There can't be two set of documents.
Lordship. But
If
at
you
the-
are, no,
At
no,
the sometime, Lordship, these are all in the public domain, Lordship.
no, no,
In the portal, Lordship.
no, no, you can't discount that.
Lordship.
You see, a document must match.
Lordship.
What is the,
Lordship,
what is the, Mr. Goswami, what is the requirement? You have to upload a document which is in a tender, which is signed and scanned and then uploaded, right? Correct. So there can't be a mismatch.
Yes.
Now come to page 20, this 135 capital A, which you are showing.
Yes.
Correct. Page 24, 134A. You see, yes, Here, we find that there is a letter pad, Deccan Associates,
Hmm.
correct?
Hmm.
In the original, the Deccan Associates is not there.
Where it is?
Page 135A, you were showing us.
135A.
Yes,
Yes, Lordship. Deccan Associate is there, Lordship.
here it is not there. I'm showing this to you.
No, this is given by the petitioner, Lordship. This is the petition, 135A is the copy of the petitioner, which is furnished by the petitioner, Lordship.
Correct.
But in my record, Lordship, it is duly there, Lordship. The
No,
signature
but
is
you
there.
see, you are showing me below down the signature of Deccan Associate.
Yes, Lordship.
How will he get it?
Lordship.
How will Mr. Chaudhary get
From
it?
the, I also submitted my document, which is downloaded from the portal, Lordship. In another, in.
What is that?
Yes,
Because you see here, the second thing is, this is a seal,
yes,
which is like this.
yes. But in 135A also, there is a seal is distinct, Lordship, and signature is there.
You see the manner in which this is put. It is like this.
Yes, Lordship.
In 135,
Deccan Associates is there.
I understand, you see. Supposing you get anywhere my name, K.R. Surana,
Lordship.
you will get it somewhere, correct? But when I'm signing the document, supposing I'm signing the, what you call the final order or what you call today's attendance order, the placement of my signature must match.
The signature,
You see, the placement of signature is not matching. This is across in the down below. It is across.
yes, Lordship.
Placement of the signature in 135A is different.
No, but this is a scan copy, Lordship. It's a scan copy, that is the original, Lordship. Scan,
is-
it may be
okay,
changed, Lordship.
Okay, we'll
It's a
get you
scan copy, Lordship.
okay, I'll get you a scanner here
Yes,
from the court. You just scan it and change the position of the signature.
Lordship, these are all the documents. This is the original, Lordship. We have already stated that two set of documents. One for uploading. They have to upload the documents as well as they have to submit the original, Lordship.
Okay,
Hard copy.
so we'll settle it. You give me the address of the portal, I'll open it right now.
No, my lord, it is closed now from on 8th.
No, he said he downloaded it yesterday.
I don't know how he did. Portal is, my lord, www.aidc limited.com.
Give it to the courtmaster, second courtmaster.
When it was downloaded yesterday.
No, this is
Item origin.
no. This was furnished to me by the department, Lordship.
Where is your copy, which was furnished?
I had submitted. It is disappeared.
Control. No. You take instructions, who are the authorities who are dealing with this portal,
Yes,
They'll have to-
NIC, Lordship.
they'll have to open it up for us.
Yes.
Then how he got it yesterday, my lord?
It's okay, we are not questioning.
No, my lord, I'm not, when I say he,
No, no,
not my
I
girlfriend
got-
Goswami,
Yes,
his
Lordship.
client.
I got it from my department, Lordship. They furnished me the downloaded copy, Lordship.
When I say
Yes.
he, my lord, I don't mean my learned friend. His client must have instructed him.
Yes.
So his client must be made responsible for making such wrong
But you
statement.
see, these two documents, give it to Mr. Chaudhary, only these 2 pages, it doesn't match. Sanctity of the tender,
No, it
We
is
will
matter
not
of
do that.
inquiry, Lordship. It is matter of inquiry, Lordship. We are saying that this
but
is
this
the
has to be
document.
stayed.
Lordship,
I have
how
to see,
it may be.
you stay, you show it. You see, we have.
Yes,
we
I
have-
will show it, Lordship. I can show it, Lordship.
Show it,
I can show it, Lordship.
show it. I've given you the two documents. Mr. Chaudhary, you can go
Yes.
for it. No, don't.
Yes.
This page 24 is same. I've put out page 24, both the documents you have produced. Page 24, which you have produced, this
Yes.
seal and signature is not, doesn't match. from your downloaded copy.
And there is a pattern of putting it. That pattern
no,
is
no.
not matching my. Pattern is slightly slanting.
No, we leave it to the wisdom of Mr. Goswami.
My lord, can I make one submission for your lordship's kind consideration? Is it not high time that these officers should be told, don't play around with court? Otherwise, my lord, a very wrong message is going on.
No, I don't know.
As
You
if,
see,
no,
Mr.
I'm just, it is my personal feeling, that's why I say.
Mr.
But
Gos-
why
Mr.
are they trying to play around with the
Mr.
process of the
Chaudhary.
court? No,
Mr. Chaudhary, you see,
The same, lordship. If we scan it,
but
if
it's not a
anyone scan
question
it,
of
no, it is
getting
the
a
same,
stay
lordship.
order or not
you do
getting a
it,
stay order.
we'll give
in
you
the
a
case.
scanner, which brand of scanner you want.
No, lordship, I think it will clarify the officials only.
Can
lordship.
putting a Telugu line,
Yes.
get it to line.
You see, we have in our court not less than 50 scanners. You just have to tell us the brand which you want, and we'll provide you same, and please shift the pattern of signature into a different mode. It's as simple as that.
No, now the position is that, lordship. Now the position is there, lordship.
So yes, my learned friend
No,
submission
no,
was
I am
yesterday.
saying
they
that
downloaded it.
this was furnished to me by my department.
No, you took it upon yourself.
Yes.
Ah,
Your statement is that I downloaded it.
yes.
Yes, my department downloaded.
I and my department are two different things.
Yes, lordship. So far they submitted. Now, lordship, one thing. Lordship. Regarding the signature, lordship. Others, lordship, I would like to submit in others form, lordship, regarding the non-furnished the income tax return, lordship, that.
You see, two things. Number
Yes.
one, we'll finish one chapter and then
Okay,
go to the
lordship,
another
lordship,
one.
lordship,
Chapter one is that
lordship.
you are saying page 135A is manufactured by Mr. Chaudhary. Mr. Chaudhary means his client, not he.
Yes, yes.
Correct.
Lordship, in
Now let us understand your argument.
yes.
Number one, you are saying that this page 135A is something which is manufactured by Mr. Chaudhary. Mr. Chaudhary means his client, not him.
No.
Correct.
I am not saying that they manufacturing, but
No.
in that.
Let me understand. I'm not
Yes.
finished with my question.
Lordship,
Number one, that is a proposition, that this is a document manufactured by the petitioner. Now, the fact that this is not manufactured is evident from the 3 pages of scanned copy which you have given to us. It contains the seal similar placed as it page 135A. Whether I have understood it correctly or not, scanned copies which you have produced is somewhat similar to 3 pages you are given to us. Page 24, it is similar, correct? And it is also fact that it is dissimilar to the original one.
the matter of inquiry, lordship.
Yes.
Now, lordship, now another thing is
No, Mr. Goswami,
whether.
you have not answered it.
Yes.
Enquiry is okay. I understand enquiry. But visually, you see, I'll show you something. Because when I fail in writ petition, I go to my roots. 165. Please read please read it loudly so that I can also refresh my memory.
Judge's power to put question or order pronounced, the judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he please in any form at any time or any witness or of the parties about any fact, relevant or irrelevant, and may order to produce of any document or things, and neither the parties nor their agents shall be entitled to make any objection to any such question or order, or without the leave of the court to cross-examine any witness upon any answer given in reply to any such question.
Correct. You can stop here. Number one, I have the power to ask irrelevant questions.
Yes, Lord.
Even if you think that question is irrelevant, still a judge has a power to ask irrelevant questions. Number one. Number two is that for a matter of inquiry, any question I can ask to the party or the agent, and that cannot be objected to. Correct. So therefore, the third alternative is, which flows from this, is that if I ask a question and I don't get a response, I am entitled to take an adverse inference. So therefore, you see, I understand my limitations, number one. And this says, if you read this further, you will find that a judge cannot dispense with the proof of the original. Now, you see, I have taken care of the fact that the original document is there. So Section 61 of the Evidence Act, that the original document must be, the facts must be proved by original documents. That is also now there on record. Now the fact is, there are photocopy the scanned copy which you have produced. It doesn't bear the same pattern of seal. Correct. So therefore, merely by saying that it's a matter of inquiry, so we stop here and we are issuing a notice to the forensic experts to give us an opinion. Until then, this tender process is stayed. You have heard about judicial delay. You will find it here in this case.
Page number 30 of the writ petition.
30.
30 of the disclaimer.
Yes.
Paragraph 5, Lordship.
Yes, I'm there.
ADC also accept no liabilities of any nature, whether resulting from negligence or otherwise, howsoever, causes arising from reliance of any bidders upon the statement contained in this RFP. ADC may, in its absolute discretion, but without being under any obligation to do so, update, amend or supplement the information, assessment, or assumptions contained in this RFP.
Correct.
Now, Lordship, we find the hard copies, signed copy, Lordship.
No. You have not understood this. This provision says AIDC does not accept any liability of any nature, whether resulting from negligence or otherwise caused arising from reliance of any bidder upon statement contained in this REF. That means if there is some wrong printing, some error in this document, for that, if tenderer is misled, you don't take a responsibility. Only that much.
Lordship,
You want me to read more into it?
no, Lordship. But at the same time, Lordship, the provision for submitting the hard copy is also there, Lordship. And we are on the basis of the documents which is submitted by the respondent.
But
or the
that is
bidder,
my
Lordship.
question. This is my third endeavor to ask you. How can you see, you have said that while scanning, the position may have changed. Now we are giving you an offer. Till 2 o'clock, you get us information from your clients as to which brand of scanner they want, to have it scanned and show it to demonstrate before me that a signature will change its position. Signature will change its position in only one show. You will find it if you care to look into the net, you will find there is a program called Penn and Teller. It's a magic show where you will find magicians coming and changing position of whatever they are writing. Penn and Teller. But to us in a tender process, to have a document scanned and change the position of a signature, that you'll have to show, otherwise you'll send it for forensic examination.
Lordship,
At 2 o'clock you can come, you can take instructions and come back. We are giving you an opportunity of consultation of your with your officers.
Lordship,
Come back at 2 o'clock
tomorrow, Lordship. Tomorrow is better.
tomorrow.
Tomorrow.
Tomorrow we have unlimited cases. My
Let it be
court
today, my
custody.
lord.
Tomorrow.
You can come it at 3 o'clock.
Lordship,
don't worry.
Tomorrow it may be better. Lordship.
I'll have to manage my board.
Let it be 2 o'clock.
Monday, Lordship, Monday. Whatever
Why not
the
after
findings will
petition?
come, it will be final, Lordship. Nothing to say. Monday.
No, but then don't.
Yes,
you
Lordship
have
is
already
saying.
issued. You see what you have already issued a what you call
Yes.
the work order.
Yes.
And somebody will be prejudiced by that.
Lordship, he's the highest bidder, Lordship, here in this case. Lordship.
No,
He's
no,
the
he
highest
may have
bidder,
been.
Lordship.
He may have been highest bidder.
Yes, Lordship.
You see, we are not examining the bid. We are examining the decision making process.
Lordship.
We got hardly to do anything with. I'm not the tendering authority. We are examining the process of decision making. You see, the options are only
One-
two. Number one, you can produce a scanner and we can scan it and do it. Number one. Second option is that we send it to the forensic experts. Because visual expert, I may, you see, I wear a spectacle, I may be incorrect in reading.
Well, a prima facie with naked eye, one can make out.
No, but since I wear a spectacle, I don't know, I may be,
No, even I wear a spectacle, but then my lord,
no, I don't know, but you
the
see,
pattern can be seen, my lord.
no, that is okay.
That
But I may make,
intricate things may not be evident enough.
no,
and-
Mr. Chaudhary. As a court, I am prevented from giving
Yes,
an opinion on
that-
visual
that-
impact.
that I know.
So that
No,
is
my lord,
the
it's a
government
prima facie
Now
case
also.
where my lord, a non-responsive bidder has been made
It's okay.
responsive.
it-
And
that's
a
for sure.
warrant has been
Now,
issued.
Lordship, another line of argument is that, Lordship. So far, it is in the public domain, Lordship. The petitioner aware with the fact, Lordship. But he had not raised any objection during the process, Lordship.
You just have to tell us that he had the access to this, what do you call
Yes,
this?
Lordship, during the process, all these are available.
My lord, we
Correct.
don't even
Yes.
know on 17/5, the result of technical bid was published. On 18/5, my lord, without informing, financial bid is open.
No, no.
My lord, what my learned friend is making all this submission, my lord? My
Let him-
lord,
his-
my lord, they never notified.
Lordship,
My lord, third question which Lordship asked was,
This is
when
the-
was it notified, in what manner?
This is
What
the
is the answer?
summary of the uploaded of the portal, Lordship. On Lordship, 17 May 2023 at 7 PM, Lordship, it was uploaded that the
Yes, yes,
financial,
that we have annexed.
just a financial bid opening date on 18 May 2023 at 10 AM, Lordship. It was published, Lordship.
Notified to comment?
Last part, Lordship. That is a summary of the finance.
It's 22, no? এখনই rules করে রাখা। এখন বুঝছেন? Time table
You come back at 2 o'clock, you just get instructions if you can open the portal from NIC portal. You may look into it. You verify it.
I think, my lord, in one of the judgment where lordship has also indicated that it is required that they should also, I mean,
Yes,
set out in the
on
portal.
that ground,
They
Lordship.
have not done, my lord. 18, what they have done, we have shown already annexed.
No, Lordship,
So you see, Mr. Chaudhary, there are
Yes.
certain things we won't comment at this moment.
Ah.
What is happening is that he has brought out a printout from e-portal, this some tenders.
Yes.
And here there is an entry
Ah.
saying that the financial bid opening was notified at 10 AM on 18/5/2023. So therefore, the only way is to look at the portal and find out.
Yes.
My lord will kindly come to for a moment, page number 258, my lord. Sorry, 259. 259. This is 17th of May. When, my lord, bidders were informed that whosoever's bids were technically responsive. Dear user, with reference to your bid submission for the tender, your shortfall document has been accepted on so and so. Thereafter, at 10 o'clock next day, my lord, if it is open, should it not be notified, my lord? Where is it?
No, that's what they're showing. You can look it into it. You can look into this.
Hmm.
Page 2 is notified, but the manner that's not for us to comment it right now in the motion stage.
Then my lord will kindly come to page 268 for a moment, my lord.
You see, Mr.
268.
Chaudhary, yes, I'm showing you this.
Yes, I'll see, my lord. Please come to page 268.
Last. Mr. Ring.
268, my lord.
268, yes, I'm there.
Yes, kindly see the date. Eight 6/2023. This is the financial bid opening summary. How it was opened on 18th, my lord?
Eight 6/2023.
Yes. This is the summary of financial bid opening.
Yes, financial bid is there. In the next page, you will find
No,
financial
my
bid
lord,
opening.
kindly see and kindly come to the next page, my lord. Kindly see, my lord, 269. On H6, the private respondent is notified. You are informed that your bid for the above tender has been accepted during financial evaluation by the duly constituted committee. On 8, kindly mark the date H6.
86.
Yes. Then on 18/5 it was done. According to them, the financial bid was opened on 8/6.
Just give me that
Yes.
page again. Last 2 lines.
Yes, financial bid opening 18/5 10 AM. Yes.
So correct. It makes sense, Mr. Chaudhary. What has happened?
Yes.
This the financial bids are open on this 17/5 or 18/5.
No, my
Correct.
lord.
Then
What
you are
I'm
given-
saying is, my lord,
then you
where
are
is
given-
where is that notice to the bidders that the financial bid will be opened on 18/6?
It will not be there. That's
Why?
what yesterday also I told you. You see, what has happened that you were given an opportunity of shortfall document.
Yes.
Financial bid is opened.
No,
Correct.
no, my lord. Kindly come to that clause. I don't think there can be any ambiguity on that, my lord.
No. You see,
Page 45.
no, you tell me if I'm wrong.
Yes.
Financial bid is open. There is a shortfall of document and they require you to give the shortfall document that you subsequently procure the
No, with all
shortfall document.
respect, with all respect, no, my lord. First, I must overcome that technical submission hurdle. It is only when I am technically, my lord, responsive, then only my financial bid will be open. That is the procedure they have followed.
What is this page 259 then?
259 is the result of technical bid. So I was informed that your technical bid has been accepted on 17/5. So the financial bid opening can be only after 17/5.
Okay.
Now,
Okay. I
thereafter,
get it.
they are supposed to, my lord, notify that financial bid will be opened on such and such.
Just show me that.
Yes. number summary. For example, my lord will kindly come to page 258. $258, my lord.
Yes,
Kindly see, my lord. This is on 29/4.
yes,
There were in all, my lord, 13 bidders. Out of which, my lord, out of 20 bids, 13 bids were accepted, were found to be technically responsive. So this is how they are to do. All of a sudden, my lord, without notifying the next day, what was the earth-shattering urgency? And when, my lord, financial bid opening summary was uploaded on 8/6, how can we presume that, my lord, on 18/6, 18/5, the financial bids were opened? My lord, what meaning we give to the expression transparency? If this is a transparency, my lord, then perhaps. My lord, in that West Bengal case, Supreme Court has clearly said the best way to achieve transparency is to follow the tender. If somebody has, my lord, violated, not followed the tender, my lord, in one case, Supreme Court, my lord, if the bidder was in possession of a particular license, my lord, but it was not given. Now, my lord, it was subsequently submitted, High Court allowed, then Supreme Court says no. By the last date, whatever you had to give.
that's a well settled
Say that,
position now.
in spite of possessing, my lord.
Now, Lordship, it is the portal.
Just now, Mr. Chaudhary. You are referring to page 259.
Yes, my lord.
259, that
Yes.
is shortfall on 17.5.
My lord, whatever shortcomings were there, taking note of everything, my lord, eventually on 17/5 at 6:50 PM, I was informed that or at least, my lord, this document was uploaded, which we got from the website.
Okay, which are the pages you are referring to show that sequence of events?
Yes, my lord, first, my lord, will kindly come to 259.
259.
Then, my lord, next page, all of a sudden, the price bid is, my lord, uploaded.
18.5.
18/5. Yes, very next day, next page, page 260. That's why, my lord, yesterday, while passing the order, Lordship has specifically posed that question. In what manner the bidders were intimated?
Okay, then next page.
Yes. Then, my lord, will kindly come to. Then, my lord, 266, my lord. This is dated 3rd of June 23. Apparently, my lord, this respondent number 7, he has already started working, my lord. 3/6/23. What did he answer?
Yes,
266, my lord.
yes.
Then, my lord, will kindly come to 268. That's the financial bid opening summary. Now, my lord, page page 269.
Just a moment.
Yes, ma'am, sorry.
Yes, 266 thereafter.
260, thereafter 268.
268.
That is financial bid openings summary.
This is on
8/6.
8.6. Yes,
Page 269, my lord, the AIDC intimates the respondent number 7 that his financial, his bid has been accepted.
Yes,
And now my lord will kindly come to page 271.
yes.
Now, the petitioner was intimated in respect of his financial bill. It was uploaded in the website, my lord. Then, my lord, 272 and 273 are the two documents, my lord, furnishing the income tax return acknowledgement, where it pertains to some other person, not the proprietor, Subendra Nath Deka, 272 and 273. So, my lord, it's in my humble submission, prima facie, it's a case where, my lord, a non-responsive bidder is sought to be made responsive, and thereafter award of the contract.
At 2 o'clock, you get instructions.
Lordship, here in this case, Lordship,
Yes,
the government e-procurement system, it is stated that the bidders will be able to see the status of the tenders for which they have submitted quotes in a different stage, and would also be informed to the status by email for bidders who have specified the product category through product category, obtain information of all the tenders published under the select product category will be sent by email. Now, these are the auto generating system of that portal, Lordship. AIDC have nothing to do, Lordship. AIDC uploaded the date, and it is in the record of the portal, Lordship. And this is the duty of the petitioner, that to go through the status of the portal, Lordship. And regarding the document which is annexed in page number 269 and 270, Lordship, and 71, Lordship, these are the auto generating, Lordship. On 18/05/2023, the financial bid was open, Lordship. As per the notification, notification uploaded in 17 at 7 p.m. Lordship. Because after confirmation of the technical bid, Lordship, the AIDC have to open. AIDC have the tendering authority have the right to open the financial bid for. These work is related with the public, Lordship, related with the food grains and all these things. So very it is necessary for it is continuous process without stop of any such circumstance. In any circumstances, it will damage for the public, Lordship, public money also, Lordship. Therefore, the AIDC on 18th, AIDC open, and 17th it is notified, Lordship. In the all the tendering process is done through this procure system, Lordship. And it is also in this system, Lordship, it is very much clarified that they have to obtain all the information from the portal, Lordship. It is their duty that to go through the status of the portal, Lordship. And
my lord, recently that state has come up with that act, my lord, where, my lord, section 17, where, my lord, the detailed procedure has been laid down regarding what to be uploaded, what not to be done, my lord. Section 17 of the that is Assam Public Procurement Act 2017. Section 17, my lord, lays down the detailed procedure. My lord, with your lordship's kind leave, can I, my lord, quote?
we'll take it about 2 o'clock.
Well, deeply.
We'll take it about 2 o'clock. You continue at 2 o'clock. In the meanwhile, you obtain instructions, whatever you want,
Lordship, regarding
at 2 o'clock.
regarding the signature.
Yes. And take a break and come back. It's item 12.
Well,
My lord, in this case, my lord, there is another order passed by your lordship last week, my lord. So what has happened, the petitioner, my lord, in fact, along with 4 other petitioners, they approached this court in 22. So by the time your lordship had taken up the matter, but in fact, we could not place before your lordship that election has already been held. So in that case, there is a direction that 2 boards, my lord, petitioner 1 and 2, they will hold election. But already from this petition, it appears, my lord, that election was already held, 5-6. Now here, my lord, they have alleged certain anomalies, my lord, in the election. So can it be this way for us to reconcile both, my lord, this earlier order and the present order that would be passed? My lord, since there is some allegations, so lordship will direct, my lord, that the allegations be considered as a, my lord, objection under Rule 27. And in case, my lord, the register, my lord, he finds that this is correct, then, my lord, he will, my lord, pass necessary order, and, my lord, the election may be held as per your lordship's direction in the earlier order. And if, my lord, election register finds that there is no anomaly, then, my lord, the order will march with the earlier order. Perhaps that can be done. Otherwise, my lord, there may be 2 contradictory orders, my lord.
We'll list this matter also tomorrow then,
Correct,
because this order has to be passed in the presence of Mr. Banik.
my lord, my lord.
Item 12. In view of order dated 13/6/2023 passed by this court in WPC 1323 of 2022, to avoid contradictory orders in order to maintain consistency in the orders,
Right.
it would be appropriate that this matter be listed in the motion column on tomorrow, along with the records of WPC 1323 of 2022, disposed of by order dated 13/6/2023.
Right. Name of the petitioner may be shown. Sometimes dispose of matter does not show the name of the petitioner. My lord. Name of the counsel for the petitioner.
Okay, the registry shall reflect the name of learned counsel for the petitioner in WPC 1323 of 2022 when the matter is listed on tomorrow. 23/6/2023.
God bless.
Itu ভিতৰত ৰাখি দিব আৰু স্লিপ দিম পঠিয়াব নহয় তেতিয়া কৈ দিব দুটা একেলগত ৰাখিব পাৰে
23.
Made to the this application is made for appointment of arbitrator. Earlier petitioner was appearing in person, but he applied for legal aid and accordingly I was engaged as legal aid counsel. But subsequent to that, my lord, the proprietor of this petitioner, he has made an application before the Secretary Legal Services Committee, Legal Services Committee, that he think me not to be competent to place his case. And he requested for engagement of someone else.
It can't be permitted.
So, my lord, as he has lost this faith upon me,
So then will not be entitled to.
yes, Lord. And apart from it, I placed one opinion that a contract of farm where it is entitled to get free legal aid. Lord, that is also.
Lordship, I have one submission, Lordship. On the last set, Lordship, we have filed one affidavit. And on the last page of the affidavit, there is a list of Lordship panel of arbitrators maintained by the department. And in the order, Lordship, we have been directed to appoint the arbitrator from that list and to get the instructions, Lordship. So just now, Lordship, I have received the instructions from the department, Lordship. We have appointed one arbitrator as per by following the order of the court, Lordship. But the hard copy, the appointment letter could not be, I could not get it because it was been informed that in the Upper Shillong for the headquarter, it's very lightning and this thing is going on also. So there is no current. Otherwise, Lordship.
Okay.
And he is present, my lord. Petitioner is personally present.
Yes.
On 2nd of May, he submitted this letter that he think me not competent.
May I speak, sir? So in the last hearing, it was, I told the lordship that I want independent arbitrator for it. And for that, I have a judgment.
So why you want to recuse Mr. Haloi?
Because I told him to give some Supreme Court judgment, and he is telling that I didn't find it. Now I have it, the such judgment.
No,
He's
no,
not listening to
number one, you are not permitted to have a legal aid counsel because your arbitration proceeding itself will disclose that you don't come within the category of persons to whom legal aid can be given.
Sir, I can defend myself, sir.
Huh. But lack of confidence, if the allegations made on Mr. Haloi, this is unacceptable. It's not acceptable.
Okay, sir.
A lawyer will move in his own, if there's a lawyer, he, even if you give him a citation, he may not take it because it is he who is to face the court.
I gave him Supreme Court number of Supreme Court judgment, sir.
No, that's
But he-
okay, but if a lawyer is there, he will move and as per his convenience, not at the dictate of the party.
I am giving him some Supreme Court judgment for my, for.
No, where is the contract agreement in this case?
He is with him, sir.
No, give it to him, he'll
Yes,
defend it.
contract agreement was not annexed. It was subsequently.
You can't take it up without the contract agreement being there. You are asking for appointment of arbitrator.
I may be released, my lord.
Huh?
I may be released.
You are being released.
I may be released.
Contract agreement is in our affidavit, Lordship, Annexa R1.
R1
Annexa R1.
page.
Lordship, internal page it is 22. Lordship, I'm sorry, Lordship, I've not got the running page number. Internal page 22.
No, we don't have the running page. Annexure?
R1, Lordship.
R1 is not an agreement.
CW replacement of contract furniture. Oh, it is the tender also.
Show me the agreement.
See, lordship, you have to get it, lordship. The contract agreement.
You have a copy? Pass it
Sir.
on.
In the next chapter, in last page of this petition copy or arbitration act 37, that is included in the petition, sir, 16 and 17 page. P8, annexure P8.
But that is the only condition. Court requires the whole agreement, contract agreement.
And the contract agreement, sir, only condition 37 is referred and no detail is given. So I have got it from another source, that condition 37, full detail of it.
And most of the list that we have annexed in our affidavit that qualifies the qualification to be a sole arbiter lordship. That says the serving officer must having a degree in engineering or equivalent, or having passed final or direct final exam of subdivision 2 of Institution of Surveyor of India recognized by Government of India, to be appointed by the authority mentioned in the tender documents.
You're reading from where?
I'm reading from the repetition of it, the last page. The condition of the contract agreement is mentioned, arbitration. Last second page, looks. Point 37 arbitration.
What is the qualification?
Qualification is
Serving officer having degree or so and so.
yes.
No,
Every-
serving officer is not required. One is under 11(6).
We
then
refer
up-
to sole arbitration of a serving officer having degree in engineering or equivalent, or having passed final or direct final examination.
No,
Sir.
we will appoint an independent arbitrator.
Lordship, our PR is basically to be an arbiter to be appointed. We maintain a panel of lordship arbitrators from the department. So our humble prayer is that if that can be done from the list, lordship.
Where is that?
That list is that lordship. Last page of our affidavit in operation, lordship. Annexer R21.
No, they are all your panel of serving officers. No, serving officer
Lordship,
may
may
not
kindly
do.
see Annexer R21, Lordship. Internal page now 41. Constitution of panel of serving officers for appointment as arbitrator.
No, not serving officers. We'll appoint an independent arbitrator, and we are appointing it. We'll not appoint your departmental officers.
Then Lordship may do it from Lordship's side, Lordship.
This arbitration clause you're not disputing.
Arbitration clause I'm not disputing, Lordship, because by following that arbitration clause, these persons, the list, they are all qualified.
No, my only question is this page 16, 17, you are not disputing. Of the petition.
No, that part I'm not, this copy of arbitration agreement. That part I'm not objecting, Lordship. Lordship, in regard to independent arbitrator, our pair is there in pair number 8 of our affidavit, Lordship. That instead of independent arbitrator, may I just read out, Lordship. In regard to the department, a similar order has been passed by this court, Lordship. In arbitration 2 of 21 lawsuits. In the year 2022.
May I say something, sir?
Yes, give me a copy.
Which copy, Lordship?
You said that you had some order of the court.
Oh, yes, yes. In this case, Lordship, one arbitrator we have appointed and the petitioner challenged it. So we have produced this list only to the court and court ordered that the substitute arbiter from that list and to proceed immediately, Lordship. That case was challenge of appointed arbitrator. Here it is demand for appointing an arbitrator.
This will not apply here. Yes, what do you want to say?
I have some Supreme Court judgment on it, that once the application is moved under section 11, the opposite party lose the power to appoint arbitrator. And I would like to submit the judgment, sir. No, Lordship. I have the judgment.
How is it relevant? How is that relevant? He is not wanting to appoint an arbitrator after you are saying, he is asking for appointment of an arbitrator to the court. But they are saying that it should be appointed of their empaneled arbitrators.
I want an independent arbitrator. That is the point I have.
In regard to his submission, Lordship, our prayer is a para number 8 of our affidavit, Lordship.
You see, your petition has to be amended. On this petition, I am not passing any order. In your petition, you have not disclosed that they had written letters to you about the arbitrators. The stand taken here is that it was the consent letter which they sent. It was reverted back to them.
Yes.
And the fact that they had offered to appoint an arbitrator, this is a fact which you have not disclosed in your writ petition. You have annexed this arbitration clause as annexure P8. To that effect, there's no statement and no affidavit to vouch for the correctness of this. In your petition, only 1 to 4 annexures are referred to. For others, you have not taken any responsibility. You have not even marked. You have to withdraw this and file again or amend this. This is not the matter. We'll entertain a petition. You see your annexures. For annexures 5, 5 to 8, there's no statement in your arbitration petition. And you are not, if you are dissatisfied with your lawyer only for not presenting that citations, he was right. This respondents are not wanting to appoint arbitrator during the pendency of this petition. They are merely praying before this court that their panel arbitrators be appointed. Your counsel was right not to produce those citations before us.
Your Lordship, I have upon High Court, Supreme Court judgment on it. That once this application is filed under 11(6), the opposite party lose the power to appoint arbitrator.
If you're not following me, I can't make you follow me. In your petition, which is the letter where you have demanded arbitrator to be appointed?
Six, annexure P1, sir, 6 to 7 pages,
Page?
6 and 7, annexure P1. That is on 31/10/2022.
Mr. Shamavara,
Lordship.
you see, so difficult to understand when matters like this come to the board. You see this in the arbitration petition without any statement, documents are annexed without any affidavit. You also file an affidavit without what you call, without addressing any of the points raised by the petitioner. So you are traveling on a different track, and the petitioner is traveling on a different track. Obviously, something like Orissa claim cash will not happen in this case. And I'm the one who was bothered by reading and trying to understand. You see, a simple thing in annexure P1, he is raised on 31/10/22 to appoint an arbitrator.
Fundamentally, is that not to be an arbitrator found up?
No. But you have not fundamentally, you are using the word fundamental. You have not even responded that what you did after receipt of this letter. The receipt itself is not denied, not accepted.
Or reply to this letter, Lordship.
Yes, in your affidavit, you have not responded anything.
Lordship, in regard to, Lordship, it is not in direct, Lordship, just one thing, Lordship. That praying the court, let's say, an independent arbiter may not be appointed and should be appointed from the list. That part is there, Lordship. In number 8 of
You
our-
see, first of all, you must say, you know the law. He makes a demand for arbitration. Within 30 days, if you don't do, now the ball is in the court. Now the receipt of this 31/10 itself is not denied by you. That means it's admitted that notice was issued to you, and you have not responded to it in your affidavit. No word about this 31/10.
There is one in regard to, Lordship, something amendment also took place, Lordship, in the contract agreement, and we have asked several times to come and sign that part.
No, that is okay. But you see, if you don't respond to it, how do I understand what is the?
No, specific paragraph comments has to be there, Lordship.
But you have not done. You see, you have some experience,
Specific paragraphs. That
and,
part
and because of that, I've been able to. I'm required to read everything and then try to understand.
That
what
part,
is it? That assistance is not there.
that part I agree, Lordship. I'm very sorry, Lordship.
We'll appoint an arbitrator from our own panel.
Lordship,
End of the matter.
very fine, Lordship,
Instead of keeping trying to understand what the matter is about.
100%, Lordship. In fact, we also want that, Lordship, department side, Lordship. Department, if court is appointed, so we have no objection, Lordship.
Third, petitioner in person. In this application filed under section 11 within bracket 6 of the Arbitration and Conciliation Act for appointment of arbitrator. It is projected that by a letter dated 31/10/2022, a request was made by the petitioner to the chief engineer within bracket AF, bracket was Shillong zone, for appointment of arbitrator, which was not done. Hence this application. Next paragraph. The court is inclined to observe that there are deficiencies in this application filed by the petitioner in person, because the documents, none of the documents appended to this application is verified to be true to records. The records are true to not verified as matter of record. Full stop. Moreover, there is no statement with regard to annexes P5 to P8 in this arbitration proceedings, arbitration petition. Full stop. Mr. Sikesh Barwar on a CGC. Next paragraph. Has referred to the affidavit in opposition filed on behalf of respondent number 2. Which does not address a letter dated 31/10/2022 within bracket annexure P1 to the writ petition bracket closed, by which request for appointing an arbitrator was made. Full stop. Next, therefore, comma, moreover, comma, by referring to the documents annexed to this, to the affidavit in opposition filed by the respondents, the respondent number 2, it is submitted that the respondents have a panel of serving officers for appointment of arbitrators. So it is projected that there was a subsequent amendment to the contract and the petitioner was called upon to come and sign the amended agreement, which was not done. Correct?
What's it?
Not done. Next one, be that as it may. As the petitioner has been able to show that, petitioning person has been able to show that a request for arbitration was made by letter dated 31/10/2022. The court is inclined to appoint. We'll do it one from our panel. We'll appoint one retired district judge
Yes.
as the arbitrator. We'll do it from our panel. I don't have the panel list right now. So as our sole arbitrator in the matter of dispute between the petitioner person and the respondents. Next paragraph, the petitioning person shall move the sole arbitrator in an appropriate manner as provided under the Arbitration and Conciliation Act within a period of 15 days from today by producing a certified copy of this order before the arbitrator, sole arbitrator, so appointed by the court. Matter disposed of.
My submission.
My submission, Lordship.
And I will.
Oh, yes. Before that, you write at the outset, Mr. K.M. Haloi Leonard, legal aid counsel, paid for recusing him from appearance in the matter on the ground that the petitioning person has lost faith on him. Full stop. Although the cause assigned by the petitioning person is not appreciated. The cause assigned is not appreciated. Next paragraph. Moreover, as the petitioner is found to be a petitioning person is found to be the owner of a firm and doing business, the court does not find the petitioner to be entitled for an illegal aid counsel, be that as it may, on the prayer made by Mr. K.M. Haloi, legal aid counsel from his exempted from appearance in the matter.
Much.
What's the resolution?
Yes,
My lord, in this case, my lord, I need some time to take instruction. On 3/5/2023, it was listed and
yes.
issued notice, but I have not received any copy. And therefore instructions, I could not take an instruction from the department. my lord.
Okay, the petitioners in person shall provide a copy of the arbitration of this application to Mr. A.K. Datta and counsel for the learned CG opinion for the respondents, so as to enable him to obtain instructions. Give a fixed date after 4 weeks. Give him a copy today. 20? 26/7, this one 26/7, so. Resume 2.
Getting into the provisions, right on that. Calling the. No, it's calling as the case. He mentioned. Company. Rates to be. Only you would say holistically, harmoniously, obviously, if they use a physical statement mean. This should be.
Where is your notification?
My lord.
Where is that
In
notification?
the statute book, my lord. The GMC Act. It's in the GMC Act, my lord. GMC Act.
Which provision?
My lord, section 180, my lord, read with that schedule, fourth schedule, annexure there, annexure 1 there.
Yes, fourth schedule.
Fourth schedule, my lord will come to the last.
Entry number.
My lord will come to the last thereof. There is, my lord, in page 194. Annexure 1, my lord.
$194.
Lordship, and down below, annexure 1, my lord.
Yes.
Trades to be included in class 1 category. My lord, serial number 11.
Huh.
private schools above 300 numbers of students. And the parent provision is 180, madam. List of constitution.
By when you will be filing your affidavit?
I have already filed an additional affidavit. Lordship will grant me immediately after vacation. In the meantime, I will file my affidavit, additional affidavit.
Give you. We'll fix it for hearing.
Lordship.
If they can file
So-
the affidavit beforehand, my lord,
Huh.
before they did, so then that will make required I'll also.
Did anything fix? Date? Right. And we say you can ask senior counsel. Assisted by Mr. MP, not on counsel for the petitioners. Mr. S. Boral, standing counsel
I am appealing for all the respondents.
for all the respondents. Raised for and is granted. Time till 20.
Let it go on 20, immediately on
20.
17, I will file my affidavit.
Within 24/7/2023 to file additional affidavit as paid for. Just reply if any. By the petitioners may be filed within
1 minute.
within a week thereafter. List the matter for hearing on 3 August
Lordship. Lordship.
2023. Huh? Just before I will admit and issue rule. In view of the nature of advance raising in this petition. The petition is admitted for hearing by issuing rule returnable forthwith without requiring any first steps to be taken by the petitioners. This is.
Lordship. Much obliged.
May I please, Lordship? Lordship, proceedings that have been going on. Primarily, Lordship is concentrating on the establishment of the child-friendly courts.
No,
Now,
this issue is the issues are expanding in quite a what you call in a astronomical manner, because you see what is happening now in the meanwhile. Various judgments of various courts, including Supreme Court of India, are proliferating in this Bachpan Bachao Andolan. Not only there is a requirement of a child-friendly court, child-friendly environment, but what is happening is that few departments have to work in tandem.
yes, Lordship.
Correct. Now for example, even yesterday we had a meeting for this child welfare committees and this all these issues, juvenile issues. Now we were informed that there are in certain aspects, there is a classification of the authorities who will act at level 1. After that, the level 2 different what do you call it, establishment takes over, and then what is happening is that yesterday we were of a view in the committee meeting. We were of the view that SOP is required to be prepared so that each department knows what is their
The things
actual
have to be
role,
clear.
the activity there. And that is one part. Second part is child-friendly court and child-friendly environment, not only the courtrooms, but also in the police stations and all. Now, since we have a disadvantage today, Mr. Nath is not there.
Actually, what had transpired in the proceedings, the last proceedings was, Worship, the Honorable Chief Justice had indicated that there were some funds under the ICDS which was non-lapsable. So
Yes.
that could be utilized for the establishment of this child-friendly course and all.
on deliberating with our, with my esteemed brother, we are of the view that we'll take up one issue at a time so that it is brought to its logical conclusion. Number one, from the last order of 8/6/2023, the thrust of the court was on the this vulnerable witness center. So therefore, this vulnerable witness deposition center, for this we'll take a, we'll ask the PWD to tell us the status of such centers in all district. That is one. Second is with regard to this this child child friendly court. And second is the child friendly court. These two are the fundamental first issues we are taking up.
Yes.
The second is with regard to this investigation in POXO offenses. What are you saying that
That would do your lordship.
for the time being we'll start
For the
with
time
this?
being, they may start. If I may add, your lordship, on the last date, Mr. Nath, learned counsel undertaken that he would file an affidavit giving the partial details. Since the matter is being posted to another date, I would pray that till that day, an additional affidavit was filed by us on 16/2/2022.
On
16/2/2022, your lordship.
Okay.
16/2/22.
Yes, sir.
এই দুটা ফাইলতে সিকুৱেন্স ঠিক কৰিব লাগিব ন তাৰমানে এইটো এফিডেভিট আছে ওপৰত আহি গ'ল ৰিপিটেশ্যন তলত গুচি গ'ল চিৰিয়েলি ভৰাই দিব হা কাৰোবাৰ কাৰোবাৰ Yes, 16/2 we have got it.
A reply was filed on the last date, your lordship, by my learned friend, Mr. Dina. However, the details prescribed in it are very partial in nature. At most of the headings, it's provided no reply at this stage. He had undertaken in the last order, it's also recorded that he would provide the full extent of details in a detailed affidavit. That may also be called for in the next date.
Except for this, But Mr. N. Chaudhary Leonard, counsel for, you are appealing for?
For the petitioners in item number 2, your lordship.
Achha,
Yeah.
okay. For the petitioner in this item number 2, petitioner in EL 60 of 2019. Mr. Arkady Chaudhary Leonard, ASGI is present. Miss M. Devi, Leonard, counsel. Place for adjournment on behalf of Mr. D. Nath Leonard, senior government advocate, as is unwell. Next para. In the last order dated 8/6/2023, the learned senior government advocate was directed to take instructions as to whether any funds received in the erstwhile integrated child protection scheme are lying unutilized. So that our direction may be issued for appropriate use of such funds for furtherance of the cause of the juvenile justice system in the state of Assam. Accordingly, the learned senior government advocate was directed to file a detailed affidavit as required by order dated 31/3/2023. It may be mentioned that in the order dated 31/3/2023, this court had made a mention that steps are required to be taken in accordance with directions given by the Supreme Court of India in the case of Sampurna Behura, SAMPURNA, Behura BHURA versus Union of India and others, 2018 4 SCC 433. So therefore, the court expects that the state will do the exercise in terms of the said judgment and file a detailed affidavit at least 2 days prior to the next date of listing. Next para. Next para. As the scope of this PIL is very wide. On the next date, the court proposes to take up, amongst others, 3 issues. Number 1, Viceroy 1, the issue of vulnerable witness deposition center within bracket VWDC required for the POXO courts. Number 2, child-friendly courts. Number 3, investigations in POXO crimes. Next, accordingly, insofar as the first 2 items are concerned relating to VWDC and child-friendly courts, while filing the detailed affidavit as already directed, the state government shall also pen down the status of constructions of those facilities in all the judicial districts of the state. Moreover, POXO investigation. Next, in relation to the investigation of POXO cases, the learned senior government advocate shall also address in the said affidavit as to whether any standard operating procedure has been finalized for the investigating officers so that the ideal manner in which such investigations are to be taken up are followed invariably in all cases which are registered under the POXO Act. So it will also be the affidavit should also contain as to whether the POXO kits required for investigations are made available within the reach of all police stations in the state. And other special requirements. So the court shall also be informed about the status of special POXO police and as to whether appropriate training are being imparted to these police officers who are assigned to take up special POXO cases, investigation of POXO offenses. And as to whether there is a plan in the state in place by which officers who are entrusted investigation of POXO matters are not taken out of investigation and assigned other duties so that a seamless investigation is carried out in POXO offenses without much delay in the investigation process. The learned senior government advocate is also free to address any other issues which are connected to these 3 points mentioned herein above. Next paragraph. A copy of the order of the court may be downloaded by the learned senior government advocate for online transmission to all concerned, so as to obtain appropriate instructions. First off, the affidavit in opposition, as the affidavit as indicated above, shall be positively filed on or before 26/7/2023. Copy to the learned counsel for the petitioner as well as to the learned ASGI. List on same 3rd August.
Should they may share a copy of the affidavit with me?
Huh?
Statement, have a copy of the affidavit to me.
But that's what I've said to you and both.
Yes.
Copies to both of you, otherwise.
In item number 3, Lordship, I am appearing on behalf of Mr. H.K. Das, Lordship. In regards to the vulnerable deposition central, Lordship, Government of Assam, PWD has submitted a report, Lordship, regarding the setting up of PWDC, Lordship, in 6/2/2023, Lordship. The updated report may be called for.
Yes.
In regards to the construction of PWDC, Lordship, the Government of Assam Office of the Chief Engineer, Lordship, has submitted a report, Lordship, on 6/2/2023.
6/2/2023,
Lordship.
This is a letter dated 4/2/2023, Lordship, wherein the chief engineer had indicated the suitability of space for setting up PWDC. In some places, it is already in place. But they need to submit an updated statement on this, Lordship.
Just wait, let me track out this. 23. It will take over. Files are not maintained properly. What is the date you are referring
It
to?
is 4/2/2023, letter dated 4/2/2023.
4 to 23. Not there.
It is addressed to the senior government advocate. Lordship.
Please pass me a copy.
Otherwise, Lordship has already indicated in the order only an updated statement on this.
It is like we said, no? That's all. We'll make a photocopy and return it to you. It is not available here. You have a copy of this letter dated 4.
I'll share it with her now. Sure.
You have seen it? You have seen this?
Yes, I've seen this. In fact, Lordship, it appears 4 places, it's likely to be functional by now. Your lordship will see serial number 1, 20 and 28. These are supposed to be over by 31-3. And Nalbari, it was already functional at that point of time.
No, you see, there are issues also. I'm not immediately equipped right now, but this annexure 1, serial number 4, Bongaigaon. Now it
Yes.
says refers to as per conjoining report of executive
Yes,
engineer.
yes,
Now that is not available.
that is not.
Now, second thing, you please come to next page, annexure 2.
Yes, lordship.
In annexure 2, the location of vulnerable witness deposition center,
Lordship.
number 1 is in inside the existing building,
Yes, lordship.
but number 3 is outside the building.
Yes, lordship.
Now you see, outside the building, there are every chances of the vulnerable witness being exposed. They may be in a protected condition, may not be in a protected condition. We don't know.
Lordship, lordship, your lordship, kindly see the third page. Lordship is referring to Chirang. Outside the existing.
Yes.
If your lordship will come to the earlier page, oh, lordship, it's outside. It's outside.
That's what I'm saying. I'm not equipped right now as to what measures have been taken by the state for the protection and welfare of the this vulnerable witness deposition center outside.
That has to be safe.
Has to be safe. The and the second issue which we are deliberating is that you see in this report, it is being mentioned that the PWD in consultation with the judicial department, correct, they have identified these places. Therefore, I am also not equipped with the information as to whether the district judges were consulted to identify these places.
Yes,
Normally, it should have been done,
it should have.
but if there is no space, we'll have to create some for the welfare of this witnesses.
But lordship, you can see the first sentence of the letter.
Hmm?
First sentence of the letter, lordship, with reference to the above, I have the honor to submit herewith one statement showing suitable space identified by this department conjointly with the respective district learned judges and also in consultation with the judicial department.
Respective districts. Hmm? Hmm. My brother is absolutely right. You see, in this letter, there's one more statement. Separate statement showing tentative financial implication of such temporary arrangements. So now, what is coming up is a temporary arrangement, and the total financial outlay
76.20.
on 9 items is 76 lakh rupees. So if you can spend so much, why not have a permanent establishment?
Yes. It will be needed for all times to come.
Okay. this is item 3. On behalf of Mr. H.K. Das, there is standing counsel for this court. A reference is made to a report submitted by the Chief Engineer PWD within bracket building, Assam, to the learned senior government advocate regarding tentative financial implication of temporary removed for setting up of vulnerable witness deposition center. First of all, we would, in the said connection, we would also like to understand what is the financial implication of a permanent structure. Therefore, the learned senior government advocate will also apprise this court about the cost which may be incurred for a permanent structure. And secondly, as to how the state proposes to secure the vulnerable witnesses if the deposition centers are located outside the existing court building. Secure the safety. And to avoid exposure to the vulnerable witnesses before they actually depose before the court. First one. The learned senior government advocate shall address the court on those issues also. Photocopy of the said communication dated 4/2/2023 addressed by the Chief Engineer PWD within bracket building Assam to the senior government advocate is retained on record. Take it after some time. List of same thing. And anything more you want in the order? May I just write it this, Mr. Akiri Chaudhary, ASGI and Ms. MDV.
May I please, Your Lordship?
Yes, this proceeding has to be stayed.
Apparently, there is an error committed. So as per section 43, either the chairman or the vice chairman has to call for it. Meeting. But as given in page 21, the copy was forwarded to the chairman. Page 21 is the later by which the prayer was made.
For information only.
The later.
No, no, you see there was a tie. And therefore there was no decision at all.
And no decision, the meeting was ultimately deferred because of the chaotic situation that occurred at that point of time. The meeting has already been deferred. No resolution has been passed.
Deferment itself is not acceptable. It will be a failure of motion. Two people did not attend. Then there was a tie.
Yes.
You can't rectify that.
Now the act says as per 28(2),
22 says, an elected chairman or vice chairman may be removed from his office by a resolution of the board in favor of which not less than half of the whole number of commissioners. 10 commissioners are there. So 5 voted against him and 5 were in favor of him. And ultimately no decision was taken, no resolution was taken. He is still serving as a chairman. So far as the prayer made in this writ petition is concerned, there is an apprehension. And that's why there's a prayer, that second prayer, writ in the nature of mandamus shall not be issued, commanding the official respondents to allow the petitioner to function as the chairman. He is
No,
still
that means, you see,
there, one lordship.
the prayer is that we will have to stay the no confidence process. Because we have to examine whether it is a failure or it is a deferment.
Exactly. It's a deferment.
Can't be deferred. You attend a meeting and if it fails, it can't be deferred. There is a judgment of this court.
And Lordship 47(1) says there should be resolution in the meeting. This was that, no resolution was taken.
No
47
further process till next date. At this time, to then counsel for the petitioner. For this urban affairs, who is appearing
Yeah, I am appearing for 4 to 8.
Other notice.
for 4 to 8? Who is for the government? No one. It's no representation from government advocates for the respondent numbers 1, 2, and 3. However, Mr. S. Biswas done counsel for respondent numbers 4 to
Yes,
13. You're there in the matter?
standing is well.
Not in this particular. Not particularly in this regulation. I'll just convey to Lordship. I'll just convey to the concerned AO who is going to appear in this.
No, this is urban affairs department. You are not there.
Urban affairs, municipal.
One I can appear, Lordship.
Yeah, that's
1,
fine.
2 I can appear. 3 is the municipal board that notice has to go, Lordship.
Oh, okay.
1 and 2 I can appear, Lordship.
No, municipal board is also what do you call executive officer. You will appear for them.
Executive officer, no, not me, Lordship. Municipal board. There is municipal board, Lordship. Doboka municipal board. So that is another body, Lordship.
Oh, okay, for 1 and 2, government Mr. CKS Barwa. Next paragraph.
One out.
The petitioner as well as respondent numbers 4 to 12 are elected as ward members of Doboka Municipal Board. Who took oath in the first meeting of the board held on 21/4/2022. And the petitioner was elected as chairman in the said meeting. Full stop. The respondent numbers 4, 5, 6, 7, 8, 9, and 12 had submitted a requisition dated 26/4/2023 before the additional deputy commissioner, Hojai, requesting him to convene a meeting of no confidence against the petitioner. Full stop. By communication dated 6/6/2023, the additional deputy commissioner Hojai convened a meeting of no confidence on 9/6/2023 Full stop. It is projected that 2 ward commissioners were not present in the meeting, and out of 10 ward members present, 5 casted vote in favor of no confidence, and 5 votes were cast against the no confidence motion. Full stop. It appears that where is the deferment order?
There was no order passed, nothing,
Oh, okay.
no resolution. And subsequent,
Uh,
today, notice issued, Lordship.
According to the learned counsel for the petitioner, the motion of no confidence is deemed to have failed. First of, however, no formal order has been passed. Full stop. Next paragraph. Per contra, the learned counsel appearing for the respondent numbers 4 to 13. 4 to 13?
4
4 to 13?
8. 4 to 8. 4 to 8.
4 to 8, okay, 4 to 8. Submitted that as per his instructions, the no confidence in motion meeting was deferred. So accordingly, a question arises as to whether the no confidence motion meeting held on the no confidence motion, which was moved on 9/6/2023, had failed. Next paragraph. Issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the panel. State and the land council for private respondent numbers 4 to 8 within 2 days. Next paragraph. The petitioner shall take steps for service of notice of the remaining respondent numbers 3 and 9 to 13 by registered post with AD. 9 to 14. Next paragraph. Requisite by registered post with AD, the petitioner is the counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next paragraph. As a interim measure until the next returnable date, the additional deputy commissioner, Hojai, Shankardev Nagar, within bracket respond number 2, shall not convene any further meeting to discuss the no confidence motion against the petitioner. Next, the petitioner shall produce a certified copy of this order before the respondent to bring the order to the notice of the said authority.
One meeting is scheduled tomorrow, Lordship. One meeting is scheduled tomorrow. He has issued notice. Planet government advocate may coordinate, Lordship. The rest, or if I get the
Submitted a copy of the
In
deferment
the
order.
meanwhile, if any, it is submitted that. It is submitted that a no confidence motion meeting has been called on 23/6/2023. By communication dated 26/2023 issued by the additional deputy commissioner Hojai subdivision under e-file number. So this is the one, huh? E-file number dated so. Next paragraph. As an interim measure until the next return of date, it is the additional deputy commissioner Hojai within bracket. Respond number 2. Shall not proceed with the proposed meeting to be held on 23/6/2023 at 1 p.m. The petitioner is permitted to produce a produce a downloaded copy of this order before the Additional Deputy Commissioner Gojai. And in the meanwhile, the learned government advocate shall also transmit a downloaded copy of this order to the said authority to bring it to the notice of the said authority. Just all.
Lordship
One
has called for the
submission
record.
which is part of the pleadings, Lordship, one submission, Lordship. Additional Deputy Commissioner is not authorized under section 43 of the Act to
But
conduct.
it's okay, we are restraining him. And we're not deciding the issue right now.
Your Lordship has called for the records of the proceeding.
No, I'm not calling. I'm not calling. The final affidavit, then we'll see. If it is required, then.
Obliged, Your Lordship.
41.
You have any instructions? Mr. Goswami? You have any instructions? You have any instructions?
Yes, Lordship. Introduce original to be original. আৰু এই হেৰিটো আমি জেৰক্স কৰিছিলো যে এইটো দিয়ে জেৰক্স Lordship, this Lordship, so far when I clarify the matter with the technical expert of the department, Lordship, it appears that this is the format which is issued tender format, Lordship, which is issued by the AIDC, Lordship. And Lordship, page number 24, Lordship, as part of appendix, Lordship, as per the appendix 1A, Lordship, that was signed by the respondent 7, Lordship. That was signed. And Lordship, in the portal, Lordship, which submitted, Lordship, respondent number 7 in the portal, Lordship, which is annex in the read petition as annex in page number 135A, Lordship. Lordship, it was given in his letterhead, Lordship. In his letterhead is there, Lordship, and it is given in his letterhead, Lordship. Now, Lordship, page 42, Lordship.
Let me follow it first.
Same thing, which is given that in the original, it is signed in the format appendix 1A, and here in the portal, Lordship, it is uploaded in his letterhead, Lordship. And Lordship, in that papers, Lordship, in the portal, which is uploaded in the portal, Lordship, it was also signed by the respondent, Lordship. The signature is there, it is visible, Lordship. Now, Lordship, page 42, Lordship, in the read petition, Lordship.
Yes.
Yes, Lordship. Lordship, in paragraphs 1, 2, 3, and 4, Lordship, submitted to the attend to the address. So it's after address, Lordship. It is, however, in case of any discrepancy arises between the online submitted technical bid and the offline submitted hard copy of the technical bid, in such case, online submission of the bid will be considered final, and AIDC will accept only those documents already submitted online in the portal. So and so is given. Now, Lordship, during the consideration, Lordship, AIDC accepted the online submission. That is given in
Annexure 5 in the writ petition, Lordship. In that case, this was signed by the respondent 7, Lordship. That's why it is accepted.
Okay. And this last 2 pages of the repetition,
Yes, Lordship.
you admit or you deny this? Page 273 and 274, 273.
273 and 273. Lordship, it is
272 and 273
yes,
A.
Lordship.
You got nothing to say on
272 and
this?
3, one is a type copy.
Lordship.
This page 272.
272, yes,
Yes.
regarding the income tax return acknowledgement, Lordship.
And 273A.
Lordship, yes, Lordship.
Do you
this,
dispute, do you
this
dispute
is-
this document or you don't dispute this document?
Lordship. 272, Lordship, the income tax return acknowledgement of one Silpa Deca.
Hmm. This document is a part of tender.
Yes,
Do
yeah,
you
Lordship,
deny
yes,
it or?
I will come to that point, Lordship.
Mhm.
Yes, Lordship. Now, Lordship. Now, Lordship, kindly see page number 149, Lordship.
Yes.
Lordship, this is the income tax return acknowledgement of the respondent 7, Lordship.
Yes.
It was submitted, Lordship. Regarding the required income tax acknowledgement, Lordship, it was submitted, Lordship. In the name of and all the documents in the name of Sumendranath Deca is submitted, Lordship. All the relevant document of the income tax returns, Lordship. So far, in the last documents which is submitted, that is the Silpa Deca, and Lordship, another one is Lordship Rituras Deca, Lordship. It is the addition to that, Lordship. It is stated, Lordship, in addition to his own document, Lordship, any other documents column is there, Lordship, and in that column, to fulfill that column, Lordship, it was submitted, Lordship, and there is no irregularity, Lordship. Minute of 25 or 10 combined minutes.
That's all.
Lordship, another query which is raised by the court, by this honorable court, Lordship, in the last order, Lordship, that order. That lordship, lordship, on perusal of the first minute, lordship, that the document which was produced by the private respondent. Lordship, in minute, combined minutes dated 25/4/2023 and 10/5/2023, lordship, which is submitted earlier, lordship. Yesterday, I submitted, lordship. Yes, lordship. In that, in page number 3, lordship, in page number 3B, the bidders, this is 620, it means the respondent, lordship. Decca and associates, so and so, Michael Kamrup, so and so, and 1020, Sanjeev Burman, another 1220, Bengal Amba, lordship. These
So that, I think I returned it to you.
lordship.
That is something I returned it to you or. Mr.
Oh, lordship,
Patel.
I will provide.
Morning.
Have been recommended as technically qualified. That was given in that minute, lordship. Others, for others, including the petitioners, have some rectification, and some others were rejected, lordship, and some other for preserved for rectification, lordship. At that minute, lordship, the respondents, along with other two lordship, they were qualified, lordship. It was specifically given.
No, where did you say it was, the petitioners was accepted? Where is that?
The qualified, lordship. It is technically qualified, lordship. That was given in page number 3B, lordship. B, column B, lordship. I take right tick is there, lordship.
That's all?
Lordship, at this moment, that's all. My submission is there, lordship.
I'll just point,
Lordship, my submission is that, lordship. Oh, yes, lordship. The technical breach often on 10/3/2023. It means in the month of March, lordship. Now, lordship, the financial breach were open on 18/5/2023. It is month of May, lordship. And this is very much transparent, lordship. The portal is open for all. Anybody can go for that portal, lordship. Those are the participator, lordship, during the course, lordship. All the technical bits where after opening the technical bits, all bits, all documents are visible for all, lordship. Anyone can go for that. Those are the participator, lordship. But without taking any alarm on during that period, lordship, after award, lordship, the petitioner came before this honorable court, lordship. He got the ample opportunity that to raise these points before the committee, lordship, before the tendering authority, lordship. And in that case, lordship, the tendering authority may have some opportunity that to go through it. But at this stage, lordship, after knowing the entire facts which is available in the portal, lordship, he came and tried to stop the entire process, lordship. Now it is which is going on, lordship. That's all, lordship. At this moment, I have not.
My lord, our basic case is the documents they have, my lord, signed. My lord, the tender they have not signed. So, my lord, it doesn't appear that it has been signed. That is one aspect. Secondly, my lord, just now while going through the, my lord, IT returns, what I find, my lord, for 2 years, he has given his own thing.
No, 3 years.
For 2 years.
3 years.
No, my lord.
I'll show it to you.
No, I'm saying from the tender, he's tender only.
Huh.
Please come
No,
to
from
my
the
lord, page
document.
149.
From the documents you have annexed, I'll show it to you. This
Page
is something,
149, my lord.
no, I should just give me 1 minute. I'll show it to you. Page 149
Yes, that's what I'm saying.
is
2023, 223.
22, 23.
Yes,
Then you come to page 172.
172.
Yes. This is for
Yes.
March 21. First line, I have examined the balance sheet of so and so.
No, my lord, this is what? Audit report.
Yes,
Ah.
it's a part of this document. So it is 30 March 2021. Then you come to page 190.
190.
Yes, this is 31 March 2020. This is I have already examined.
Yes. Now, my lord will kindly come to 219.
219.
Yes. Why this is required, my lord? That means he doesn't have 50 lakhs turnover.
No, the financial examination I did not do.
My lord, 219, then kindly come to 220, 228, Rituras Deka. My lord will kindly come to page 35 for a moment. At least from the balance sheet, I couldn't find that he has a turnover of 50 lakhs average in the 3 years. Page 35, my lord, on top. Party bidder should have minimum average annual turnover of 50 lakhs. He's not even paying tax, my lord, for 22-23. He hasn't paid any tax, income tax. Maybe he has suffered loss. Kindly come to my lord, 149.
35.
Can you see my lord, tax payable?
35. 35. Where is that clause?
Yes, based on top, my lord, serial number 9.
Minimum
The
average
party
turnover.
bidders should have a minimum average annual turnover of 50 lakhs. Apparently, he doesn't meet of his own. That's why he's. My lord, there's one judgment of your lordship exactly on the same point. Yeah. This is on, my lord, not signing of the document, my lord. My lord will kindly come to paragraph 8 of the judgment.
Just a moment.
For 22, 23, my lord, it could be, but for the other 2 years, it is
Just a moment. Just a moment.
Okay. What are the 50, right? A particular year or income due to the turnover, na? Gross income, no?
No, don't worry, this is something I can understand, so.
Investment, loss, residual balance. My lord, I got it.
Okay.
Please come to page 184, my lord. On top. Gross profit from trading 30 lakhs. Then my lord will kindly come. This is for my lord 21, 31,321. For 31,320, please come to 206.
Just
34.
Just a moment.
Yes. So his entire income during that year is, my lord, 34 lakhs in March ending 31,3 and 34, and in 31,321 it is 30 lakhs.
No, you
So
see,
question of his turnover, the turnover is a gross receipt. Gross receipt.
no, for a, there are two
Well, his
concepts.
income will be reflected in the income and profit and loss account.
No,
Sorry,
no, there are two concepts.
yes. No, my lord, as I understand, there's a concept called gross receipt.
No,
My lord, whatever
I'll explain to you. Two ways of looking at it, which is right, I don't know, but there are two ways of looking at it. Number one, that assuming, I'm just taking it to make the mood lighter. No offense against you.
No.
Your instructing counsel, let us say his what you call the bills raised by him in course of the year, say is 1 crore rupees as professional bills issued. But realization is 20 lakh, 80 lakh is not yet recovered. For the lawyer, that can be a concept. Receivable, amount receivable. Second concept for a contractor is, number one, he does the contract, he doesn't get a bill. So he will say gross receipts, and then he will say work in progress.
But it must be reflected in the balance sheet. Where is
It
it?
is there, that's what I'm showing. Page 183. Gross civil receipts is 28 lakh 7,000. Sales from residential project is 91 lakh.
Okay.
And then next is work in progress. So his directed closing work in progress, and therefore the work in progress is 89, 17, 713. Therefore the
So balance is 30.
transferred 30 lakh transferred to that account.
Hmm.
And in the second case, you will find it that is page 202. Sorry, 171.
No, at 205 also, my lord.
171
Hmm.
and 205.
Yes, here also 38 lakhs. And maybe he meets that turnover criteria he meets.
No, we are not on that, but broadly,
Ah.
your argument is that the tender is not.
Acceptable.
uploaded.
And this judgment, my lord, which I have given, my lord. If a lordship would kindly come to para 8. Now, if you kindly come to the 5th line, sentence starting with it was submitted at page, my lord, 8, para 8, 5th line. It was submitted that all documents were not digitally signed and therefore the bid of the petitioner was having a non-curable formal defect, which went to the root of the matter. It was submitted, all the documents appended to the bid was required to be digitally signed, and that all the documents are required to be compiled into one profile, which was done by the bidder, other bidders. It was submitted that these instructions are to the effect that if the entire documents are converted into one file, it ensures all pages are get digitally signed and there is no chance of tampering electronic document. This was the contention of the state, my lord. The allegation was the documents were signed, tender was not. And
In
my lord
this-
will kindly come
in-
to.
In this case, I did something unprecedented. I called the technical people of
Yes,
Ampron,
Ampron, yes.
and I came down and saw how it was being
Operates,
operated.
yes. Now kindly see, my lord, para 15, lordship's operative finding. Therefore, the court is constrained to hold that except for the index page, none of the bid documents were digitally signed or converted into one single PDF file before uploading the online e-auction platform for the auction held so and so, which was maintained by Ampron on behalf of the tendering authority, Environment and Forest Department. Resultantly, uploading of the bid by the petitioner was not in accordance with the direction contained in the bid document, read with the instructions of so and so. The court is also inclined to hold when bid submitted by petitioner is not in accordance with the bid document, read conjointly with the instructions provided by the so and so, the bid submitted by the petitioner had suffered from material. So same is the case here, my lord, that the documents were digitally signed and neither it was put in the one PDF form, nor, my lord, it was same is the case here. The documents they have signed, and my lord will have seen the clause whereby it is said that while first download, sign, then upload. So therefore, my lord, there cannot be difference between the hard copy and the online copy. It will be same. That being the position, my lord, the tender is defective, my lord. So defective tender ought not to have been considered by the authority, my lord. I do not know on what basis my learned friend is making the submission that he has signed. Therefore, my lord, at this stage, it will stay the operation of the order, my lord.
Let's consider in pass for this. Your originals are kept with me.
Deeply obliged.
We do 25.
25 and 26.
It's 25. Volume requires this to be admitted.
I beg your pardon, my lord?
The volume requires this to be admitted.
My lord, so far as our cases are concerned, if it is admitted and my lord fixed for hearing, it will take a still longer time. Because as my lord knows, the mega structure, the construction of embankment, flood control measure,
Oh, this is that.
downstream of river Subansiri.
Oh, that is this. This is that matter.
Yes, my lord.
Okay.
Lord Senior Counsel, Mr. Kane Sudri sir was engaged in this case. Just kindly pass over the matter for time being, my lord.
Okay.
You'll meet a court. Oh, obliged.
My lord, I can start, but I don't think it will conclude today, my lord.
But I have to begin because
Ah.
because of the infrastructure issue involved.
Yes,
I'll have to begin.
yes.
41 capital A.
Not exactly, my lord. My lord, if there is violation of the, my lord, that the Bholenath, that case, the Honorable Supreme Court has clarified that. My lord,
In Bholenath, my lord, the thing was clarified. Supreme Court only said the
No,
ratio
no,
is not
you don't have to-
applicable
You don't have to
because
respond.
construction of staff
Mr.
quarters.
Tiwari, you don't have to respond
Very
because now it is the board of.
no,
Very
my
well.
lord,
Sorry.
my lord, that judgment in that NG exports, of course, it's a judgment given by Supreme Court, therefore it's binding on all of us. That going by the subsequent, order, I think, my lord, there are reasons to believe that the tone and tenor of the judgment has been diluted to a large extent. Let us, my lord, because that's a very important aspect, my lord. The judgment condition, hold enough to.
You know, what was my initial grooming up?
How can it be, my lord? Supposing an tendering authority says the sun rises in the west and it is relating to a, my lord, infrastructure project.
No, this
Therefore,
should
lordships will close the eyes.
No,
Can
that-
be, my lord.
No, that is why you see, I tell you, the initial grooming up
Ah.
at the school time was by referring to Mahabharata. My Guruji told me
Ah.
that this epic, Mrs. Chaudhary,
My lord.
this epic was recited by Vedyas
Yes.
and it was written by Sri Ganesh. Therefore, I was told at that point of time that even if that epic contains contains anything which is wrong or incorrect, or even if it is grammatically incorrect, we'll have to accept it as correct because God cannot make any mistake.
That's good. No, my lord.
So I was told that not to question anything, assuming I find some error there. So I am not to question it because of the sanctity given to it by the scriptures. So the grammar has to be read in the manner, for that book, it has to be read in the manner it is written.
No, my lord, I was only wondering, then why this 226, my lord? It is called the basic structure of the Constitution. My lord, I accept everything. Maybe, my lord, the idea was sometimes what happens, the matters are not being able to taken up. Stay prolongs eventually it has an impact. But that does not mean in an appropriate case where a citizen or a person comes before a lordships and makes out a case. Why your lordships will not pass an interim order if otherwise the subject matter cannot be protected? And simultaneously, civil procedure code has not been amended. It is only in case of those cases covered by specific relief act. I don't think, my lord, that analogy will apply every time a 226 petition is, my lord, filed wherein, my lord, otherwise, where does the citizens go, my lord, to raise this controversy? So therefore, my lord, a rational view approach has to be taken. Idea is get the matter heard. My lord, yes. Oh, is it an infrastructure project? For 20 years, a project is going on. NSI, DCL, what they are doing for the last 20 years, my lord? Now they are to address the downstream impact. It is regarding that. Now, my lord, for 20 years doing, in Guwahati, my lord, we are seeing this water supply is going for the last 10 years. So tomorrow, if a litigation comes up, a person who doesn't even submit tender, work is given to him. Will the court not interfere because of, my lord, 41H? Therefore, my lord, a restricted meaning has to be given. Jail. My lord may kindly take this item, WPC 1118 of 23.
Yes. 118.
Yes. My lord will kindly come to, this is a work for my lord. Page 19 is the NIT, my lord. Bank protection, erosion control measures on the left bank of river Subansiri, adjacent to village so and so. So 29 kilometer, that is to 30 kilometer. Now my lord will kindly come to page 39. This is the part of the bid data, my lord. Please come to page 39, serial number 6.
Page
Page 39.
13.
The schedule for the, my lord, different, my lord, stages are given. I'll have your kind attention to serial 6 and 7. Deadline for online submission of bid 38/22, and deadline for offline submission of bid is towards the down below, my lord, 29/22. This has got relevance. That's why, my lord, I have drawn your lordship's kind attention. Then my lord will kindly come to page 41. (41) 2.1b, my lord. All bidders meeting the qualification criteria as defined in clause 3. That means, my lord, all bidders who meets the qualification criteria as defined in clause 3. And clause 3, lordship finds at next page, my lord. All bidders shall include the following information and documents with their bid in qualification information unless otherwise stated in the ITV. So
That is page,
amongst,
that is page.
my lord,
That
page
is the-
42, my lord.
Ah.
Next page.
Is 3.1.
3.1a, my lord.
A, okay.
3.1, all
Okay,
same, my lord, all
Ah.
3.1.
Okay.
All bidders shall include the following information and documents in their bids in qualification information and otherwise stated in the item. Then if your lordship would kindly skip over to the next page, my lord, 43.
Just a moment.
Now, for the purpose of the present case, my lord, 32bi, Roman 1 is important. Each bidder must also produce with their bid PAN number, GST registration number, and employees provident fund registration number. Now, my lord, apparently, the bid of the, my lord, the successful bidder, his, my lord, he did not submit this EPF registration number with his tender. After the last date of submission of bid, my lord, one document was taken from him and subsequently his bid has been made responsive. Now, I have already indicated, my lord, 38/22 was the online bid submission date, and for offline it was 2nd of September 22. Now, my lord will kindly come to page 52. Page 52 on top. Amendment to the bidding document under the scheme of the ITP, my lord, in certain situation, subject to the conditions laid down herein, my lord. bid submissions there can be amendment of the bidding document. So therefore, time is there. Before the deadline for submission of bids, the employer may for any reason, whether at its own initiative or in response to a clarification requested by prospective bidder, modify the bidding document, issuing the addendum. For example, my lord, normally pre-bid meetings are held for this purpose. Somebody, my lord, sometimes some bidders may raise a query how to. In that case, my lord, before last date of submission of bid, it is possible. So that is permissible. I'm showing, my lord, that what they have done is not permissible. Then my lord will kindly come to page 57. Before that, my lord will kindly come to page 56. 16.1. Page 56, clause 16.1.
I think other matters may not be taken up.
Yes.
So this is going to take some time. So
Yes.
the members of the
In
bar.
any case, my lord, hardly.
No, whatever, I don't
Yes.
want so many
Yes.
sitting. Yes.
My lord will kindly come to page 56, 16.1. Complete bid must be uploaded at the portal and hard copy of the document as mentioned in clause 15.2 of ITB must be submitted at the address specified by the date and time stipulated in the bidding data. Then my lord will kindly come to 16.4. Now they might harp on this clause, my lord. Therefore, I thought it appropriate to draw your lordship's kind attention. 16.4. Any alteration, modification in bid or additional information supplied subsequent to the bid after period of bid submission, unless same has been expressly sought for by the employer, shall be disregarded. My lord, a leeway has been kept in the tender that even after last date also, if it is sought for, it can be done. Now the issue is, my lord, whether this clause can be given and they can be read in isolation or it had to be read in the context of the scheme of the ITB. I'm reading it again, my lord. Any alteration, modification in the bid or additional information supplied subsequently to the bid after period of bid submission, unless the same has been expressly sought for, shall be disregarded. So in certain situation, maybe the employer or the purchaser, they may, my lord, ask for some information in which otherwise it should be disregarded. Now my lord will kindly come to 18.1. Information. Additional information.
Was this heard earlier? There are too many markings here.
I know. Maybe at the interim stage, no? At the interim stage. Then my lord will kindly come to 18.1. After submission of the bid, the contractor can resubmit revised bid any number of times, but before the stipulated deadline for submission of bid. Or 18.4.
17.
Huh? My lord, kindly come to 18.4. No bid shall be withdrawn or modified, revised in the interval between bid submission deadline and expiration of the bid validity period specified in the bid document. Anyway, 18.4 may not be very relevant. 18.1 is very specific, my lord. Now, I'm sorry, my lord, I ought to have referred to clause 17 also. Online submission of bid will not be permitted on the portal after expiry of the submission time, and bidder shall not be permitted to submit the same by any other mode. Similarly, hard copies of the online document if received by the employer after the deadline for submission prescribed in the bidding data, then will be considered as late bid, notwithstanding the fact the bidder has uploaded the bid online within the stipulated deadline. In such a case, uploaded online bid on portal shall be considered as non-responsive and shall not be processed thereon. Pardon. Now, my lord, if we read the clauses as a whole, what clearly emerges is after the last date of submission of bid, you cannot improve your bid. আচ্ছা এখনো কপিটো না করেন এখনো কপিটো আছে নাই একটি ফাইলত যে আছে এখনো এই ম্যানুয়াল কোনো কপি আছে নাই তাহলে একটু দেখতে দিচ্ছি Now, my lord, at this moment itself, if your lordship will kindly take the এখনো একটু গাছি দিছো নাকি 17 specific এখন maybe report note is 40. Next thing, huh? My lord will kindly give me 1 minute, my lord. Clause 7. Right? My lord, if your lordship would kindly take the affidavit filed by the NHI DCL in the other matter, my lord. And to file to the 132.
I'm having it.
Yes. My lord will kindly take that affidavit for a moment, my lord.
In this, what you call, writ petition number
132, my lord.
132.
Yes. There they have annexed the contract manual, my lord. Oh, sorry, it is there here also. I'm sorry, my lord. Lordship need not go to that. 20. Seven. Clause 7 to 7, 4. 7, 4 and 5, no? No, it will look good for us, no? No, it's page 278. My lord will kindly come to page 278. This is their own manual, my lord. Please come to page 278, my lord.
Yes.
Clause Roman 4 and 5. This clinches the issue, my lord. During the bid evaluation,
This is the part of manual.
it's their own manual, my lord. In fact, it is there who have annexed the document. During bid evaluation, the employer may ask the bidder for clarification of its bid on minor non-conformity. The request for clarification and response shall be in writing. No change in the price or substance of the bid shall be sought, offered, or permitted. My lord, if as a result of any clarification sought, a non-responsive bidder becomes responsive, then that is something which is not permitted. In this case, my lord, employees' provident fund registration was not given. Therefore, that's fatal.
Part of the
So, that's the eligibility condition. That's a mandatory condition. So, my lord, their manual itself says only, my lord, certain minor non-conformity is there, in which case, my lord, some, but that too, that should not have the potential of making either a responsive bidder non-responsive or a non-responsive bidder becoming responsive. Roman 5, my lord. After concurrence of finance, the recommendation of the tender evaluation committee shall be put up to the appropriate authority for consideration and approval for opening of the prize bid or award of the work as the case may be. Pursuant to the approval of the competent authority, concerned department responsible for award of the tender shall intimate the techno-commercially quoted bidder the date and time and opening of the prize bid. My lord, first, they will have to arrive at a decision who all are the technically responsive bidder. Then after taking approval from the finance and others, then my lord, it will be intimated to the technically responsive bidder for opening of the prize bid or for award of the contract as the case may be. Now, keeping this in mind, let us see, my lord, what has been done in this case. Now, my lord will kindly come to page 58. Examination of bids and determination of responsiveness. So it is in the clauses are in tune with the, my lord, their manual. During the detailed evaluation of technical bids, the employer will determine whether A meets eligibility criteria in clause 2 and 3. My lord, clause 3 speaks of that amongst others, PAN, GST, EPF. So he doesn't have. Then 21.2. Who is a substantially responsive bidder? Substantially responsive bid is one which conforms to all terms and conditions and specification of the bidding document without material deviation or reservation, etc. Then my lord may kindly come over to the next page. A, which affects in any way, substantial way, scope, quality, and performance of the work, which limits in any substantial employer's right or the bidder's obligation on the contract. C is very important. Whose rectification would affect unfairly the competitive position of the other bidders presenting a substantially responsive bid. So if you resort to rectification of a bid, then what will it will happen? It will unfairly affect the competitive position of a bidder who is otherwise responsible. Now kindly see, my lord, who is a not substantially responsive bidder. If a bid is not substantially responsive, it will be rejected by the employer and may not subsequently be made responsive by correction or withdrawal or non-conforming deviation or reservation. 21.4. During techno-commercial bid evaluation, employer may at his discretion ask any bidder for a clarification of its bid. The request for clarification and response shall be in writing or email or through portal. However, no change in price or substance of the bid shall be sought offered. This is what I read from the my lord, their manual. Ditto ad verbatim same. If clarification or my lord, anything which is done after the last date has the potential of making a non-responsive bidder responsive, then this is not permissible under the scheme. And my lord, in the affidavit position, they accept all this position. Now, my lord will kindly come to page 237.
Go on, Red.
237, my lord. In fact, my lord, I think lordship has the occasion to take up the matter at the motion and stay. No? If lordship has marked it, I don't know. Of course, we do not have. The interim order in this case was granted by lordships.
Oh, achha.
Maybe that is why. Now, please come to 223, my lord.
Because I found wherever you are referring to, there are flags and there are markings.
I referred it. Yes. My lord will kindly come to page 223. This is the, my lord, the proceedings of technical evaluation. Now, page 223, Brahmaputra Infrastructure Limited He is the respondent, my lord. Now, if your lordship would kindly come to page 224. Page 224, serial number 10, my lord. Valid EPF certificate submitted in the name of Messrs. Brahmaputra Consortium Limited, not as per NIT. Now, my lord, now we'll come to page number 237. To open the price bid of the following techno-commercially responsive bidder. One is SIPL, I mean, SIPL infraction, sorry, so and so. JLD, that is the petitioner.
Yes.
Now kindly come to B. Not to open the price bid of the following techno-commercially non-responsive bidder. Serial number 3 is private respondent. So, my lord, they were declared to be technically non-responsive. Now, this is dated, my lord, 29/11/22. These are the people, my lord, who talk of,
No,
my lord,
page, I'm
infrastructure
distracted.
project, there is
Page.
delay.
Page.
Page 237.
Yes, I'm there.
Kindly see, my lord. B, capital B,
Not to be opened.
not to be open.
Serial number 3.
Serial number 3 is the respondent number 6. So his technical bid was rejected. Now kindly mark the date, my lord, 29/11/22. Because they are so urgent. When a stay order is passed, everything becomes urgent. Kindly see what they are doing, my lord. 5/8/2022 can I get it? কি ডিসিশন ললে যে 10-12. Yes. Now, my lord will kindly come to the next page. Earlier, I was responsive, my lord, and the respondent number 6 was non-responsive. Now, I am being made non-responsive, and he is being made responsive. Well, am I not entitled to notice, my lord, in such a situation? All right, maybe you have a power of review. Am I not entitled to notice? In which case, I could have persuaded the authority why my bid is. Now, kindly see the reasoning, my lord. Now, this is, my lord, though it is dated 5/8/22, but the signature down below, my lord, it is 10/12/20.
5/8/22.
No, my lord, actually, the proceedings were signed on 10/12/22. Kindly see, my lord, towards the bottom, the signature is of 10/12/20.
In continuation of text 429/11/20.
Now, yes.
Earlier is only a reference number.
Yes.
Reference is NIT 58.
Yeah, oh, right. Now, my lord, may I read? In continuation to TEC Technical Evaluation Committee report dated 29/11/22 and observation of the Finance Division during concurrence at so and so, the committee deliberated on the matter again as under. Serial number 1, my lord, SIPL, that is the petitioner, Krishna Nagar so and so, so and so. The firm has submitted contractor registration from RWD against so and so. The firm has submitted along with the bid a contractor registration certificate dated so and so from Bihar, wherein it has been mentioned that firm so and so is a proprietorship firm. However, the firm had participated in the bid as a startup as per startup firm certificate. Messrs. SIPL infraction is a partnership firm, whereas the contractor registration certificate has been issued against proprietorship. Hence, as per clause 3(2)(a)(c), the firm does not qualify the tender condition. Technical committee recommends to consider the bid of SIPL as non-responsive. No notice, no nothing. Now please come to the other part. Brahmaputra, there is R6, so and so, farm had not submitted EPF certificate in the name of the bidder, that is Brahmaputra Infrastructure, as required against clause so and so. The farm was asked to submit the same. Against the same, farm has submitted a copy of the so and so, only wherein the name, the name of the farm is mentioned as Brahmaputra Infrastructure Limited, that is in the name of the bidder. During deliberation, the committee was also informed that the bidder has submitted document issued by EPFO Regional Office Delhi regarding change in the name of the EPF registration from Messrs. Brahmaputra Consortium to Brahmaputra Infrastructure Limited in the tender document for the work, riverbank protection, etc. So and so, so and so. White letter dated, kindly mark the date, my lord, 10/12/21. The committee opines to consider the same towards qualification of the bidder in this tender. In view of the same, the firm qualifies the tender condition of the NIT. The TC recommends to consider the bid of the Brahmaputra Infrastructure as responsible. So I am out, the other party is in. My lord will kindly see the last date was, my lord, the delay is there. Yes. My lord, the last date of submission of bid was 2/9/22. And this decision was taken on 10/12/22. If it was, my lord, offline, then it was 2/9. If it was online, then it was 38. Now, as far as my rejection
just a
is
moment.
concerned, my lord,
Just a moment. Online submission, you said is date 2/9.
308/22. And offline is, my lord, 2nd September 22. It to manual we go. We get 38/22 last date. If your lordships would kindly come to page 244, my lord. It was given on 29/9/22. Now, my lord, if your lordships would kindly come to 238 once again, my lord. Last para,
Which page?
my lord, page 238. My lord, there is no dispute that the EPF registration, which was submitted along with the tender, it was in the name of Brahmaputra Consortium. Brahmaputra Consortium was not the bidder, man. Bidder was Brahmaputra Infrastructure Limited. So EPF certificate has to be in the name of Brahmaputra Infrastructure Limited. Now, that tender technical bid evaluation report, which I had, my lord, exhibited, wherefrom it clearly emerges that it was in the name of Brahmaputra Consortium. Now, what they're trying to say, my lord, during the deliberation,
Just a moment.
bidder is Brahmaputra Consortium Limited, and the EPF registration certificate which was submitted was in the name of Brahmaputra Consortium Limited. It is something like, my lord, I am offering a car on lease.
So
to a
just one,
company,
bidder is Brahmaputra Infrastructure Limited.
Infrastructure limited,
Oh, I'm sorry.
yes. A document to go. A document to আমাদের আছে নাকি?
Okay, I get it.
হ্যাঁ?
Yes, it's okay. The bidder is, you are saying in Brahmaputra Infrastructure, they give document of Brahmaputra Consortium.
Consult.
Hmm.
So that is why it was rejected, my lord.
Hmm.
I may just indicate to that, my lord. If your lord's in my head in that one. টেকনিক্যাল ভিডিও যেটা ক্যান্সেল করে দিছিল যে দেখালো না মাত্র 237 আছে if your lordship would kindly come to page miles নহয় নহয় 237 228 আছে yes please come to page 224 for a moment my lord 224
224.
serial 10
Yes.
valid EPF certificate submitted in the name of Messrs. Brahmaputra Consortium Limited, not as per NIT. So this is the ground why his tender was rejected. Now, my lord, I am asking a question to myself. Supposing Guwahati refinery wants to procure vehicle on lease. So nowadays the policy, my lord, everything is being outsourced. Now they say the bidder must be a registered owner of the vehicle. Lord, on the date I submit, not KN Chaudhary, Lipi Chaudhary is the registered owner, I submitted the tender. Then I write a letter, I am trying to change over the ownership. Please consider my case. In the meantime, will it happen, my lord? Same thing is here. My lord, the sanctity of the tender process will be compromised the moment all these things starts. My lord, end of the day, it's a commercial transaction. No right is involved. No right is involved. There is an offer. If you accept, then only a contract will emerge. At that stage, you are only a person who has promised to do something, nothing beyond that. Now, how can lordships concede so much of power to the authority in the name of infrastructure? These big words. End of the day, my lord, when people will get justice done. Therefore, my humble submission is, my lord, the best way, as has been observed by the Supreme Court in that West Bengal case, Patel Engineering, best way to ensure transparency is to stick to the tender conditions. Now, my lord will kindly come to page 245. তারিখ সারিখ কিবা আছে নেকি? এখন তো 29 তারিখে দিছে নিশ্চয়। না 29 তারিখে তো না তারপর দিছে। হ্যাঁ 244 Now kindly, my lord, for a moment, lordship will kindly come back to 244. Why this benevolent gesture, my lord? Instead of rejecting the tender, as if, my lord, there is no other party in the world to do that work. Rocket science is involved. Kindly see, my lord. On 29/9/22, it is the HPCL instead of technically rejecting him, they're writing now. Where from they derives this authority, my lord? After that is changed. This is in reference to the absorbed subject matter and the tender submitted by you. In this connection, you are requested to submit the following document. EPF certificate. My lord, this is a document whereby they are violating their own, my lord, that manual, where it says you cannot resort to something which will result in upsetting the, my lord, merit list. A non-responsive bid is sought to be made responsive. You are requested to submit above requisite document within 7 days from the date of issue of this letter through email or by following the original through post, failing which or offer will be shall be evaluated on the basis of the available documents. My lord, what was the compulsion, my lord? What necessitated this? Is it a bona fide exercise of power, or it is an exercise of power for collateral reason? And my lord will kindly come to that tender bid evaluation sheet at page 237. No question. I can. Why they have shown this, my lord, compassion towards this private respondent? My lord, it starts at 217. For example, my lord, deliberation, please come to 219, to non-qualified. No? My lord will kindly come to page 220, serial number 19. He is a party from, yes, Assam. 19, my lord will see declaration for applicability of startup submitted blank, not as per NIT.
Where?
Page 220, 220, my lord.
220.
Serial 19.
24 remark non-responsive.
Serial number 19. A declaration for applicability of startup submitted blank, not as per NIT. He should also been given an opportunity. In fact, Supreme Court has said, if you're exercising the power of relaxation, then it should be done across the board. Then my lord will kindly see, come to, next is one Mr. Pallab Setia, Guwahati. Serial number, see, please come to my lord, serial number 4. Self-certification that the item offered meets the local content requirement for class 1, not submitted, not as per NIT. Why this special favor was shown to Brahmaputra? It's very interestingly, my lord, this contractor called Pallab Chetia, it starts at 221. If your lordship would kindly come to 222, last sentence in bold letters, my lord. Hence, the bidder is not qualified as per NIT clause so and so. 2AB, same thing as us. Now, as far as Brahmaputra, I have already shown. Then then 225, one Mr. Kulen Hazarika. He has also not given that self-certification certificate, so not as per NIT. All my lord 3 to AB. Okay, so
Where is that? Kulen Hazarika?
yes, my lord.
Page?
Kulen Hazarika is page 225.
225.
And the operative is at 226. 226. Hence, bidder is not qualified as persons. Serial number 5, my lord. Bidder is qualified as per delay. No, he was found to be non-responsive again under 3.2 AB. Page 26. SIPL. Then, my lord, as far as the next contractor, one TKJ Infrastructure, it is a Delhi-based firm. At page 229, it did not at serial number 7, registration certificate issued by government, semi-government, registration allowing undertaking work, not given, not as per NI. Then there was another call, High Techno Eco Green. Then his some declaration of startup was not given, so not as per NIT. JLD construction, I mean. So, my lord, my lord, the authority must also explain. They must also show. So they must also show, my lord, that why this special treatment was given. I think, my lord, today, I think for today.
Today I have to end. Because now I am becoming non-responsive.
My lord, next
It's not
week,
really-
it may not be possible. Lordship will have the immediately on reopening, my lord.
I'll take it up next week. Because if I'm starting hearing, I
Okay.
can't adjourn it.
My lord, not on Tuesday, my lord.
Okay.
Lordship can have it on Wednesday. At least I can complete. I'm sure there will be motion matters.
Okay, 28 then.
কি বস্তু? আচ্ছা, আচ্ছা।